card for a parking problem.
And 4 in your 23.
Yeah, that's 4, I'll get a 28 from one truck when you're ready.
Go ahead.
The one truck, White Lincoln X-ray 985, should come back up next.
So you had 2000. Patrick Spalding.
10-4, if you can just put a little note in something like that, I'm going to be leaving a note on a vehicle if I can remove it.
What? What? Rockingham 505. 505 and shipping Dillison case for Athens, complainant, soon to be ex, slashed her tires and has made threatening comments to her. She's concerned he might return.
Yeah, forgive this at 32.
10-4. You're assigned to a vandalism case in Athens. Did you copy the 505?
Yeah, 4. Look at that. No, 3 in Depot Street. Truck away at 35.
7435.
10-4.
10-4.
You can go 643 again.
143.
You go with that 43 you had. I didn't hear any, but I had just looks like we do.
10-4. I just wanted to know if you should be put back 76 to Cabana Circle or to the subject's address.
Yeah, I'll be 23 back on that town property case, and I'll be 76 to the Williams Road address to see if I can find the owner.
10-4. 449 1120.
449 1121, thank you.
10-4.
Code 4. 4.
Alright, we have 535.
Yeah, that was a great college.
535.
Should be. There's no number of women who walked into the house. I'll slide up that way.
Caller is now been able to close the front door. She's now pounding on the door, trying to get in still. No flights blown up on her here. Got tie-dye shirt on. And number 21 is on.
We have separation. Inboard now. She's ready. Okay, good morning, everybody. In a couple of seconds, I'm going to bring in Jen Coffindaffer, and we'll see how many other surprise guests do we have here. You know the usual cast of brilliant people that we have on. I just want to, before I bring Jen in, just want to say, and this is more a message to myself and a reminder to myself that I do somewhat regularly on the channel, that it is something directed at you guys. But we always have to be careful to do a lot of self-reflection daily when you're covering something like this. Make sure you're being fair to both sides, to all sides. Um, Someone is on trial for their life, and at this point, they have not been convicted by a jury. And so you always have to go back on that. All things are possible in life, right? That it's possible that Karen that it's possible that the prosecution has the correct argument here and an overwhelming evidence. But conspiracies and corruption and cover-ups do happen. So everybody should try to approach this with an open mind. And at the end of the day, it will be a jury that decides, not us. Now, that doesn't mean we can't weigh evidence. And we've been doing that, and we do that all the time here. We should try to weigh each piece of evidence objectively in a both sides kind of way. Again, that doesn't mean we can't weigh it. So I can, for instance, look at the GPS data, which shows that John did not go in the house. And then we can also compare that to the health app data, which suggests he went up and down stairs. Well, we don't have to just present that in a neutral way. I have researched this on my own, and you can research this on your own, and you can make a determination of which of those data streams are more reliable. And so you can do that with a case, and that's what we've been doing. But we want to try to be objective with each and every piece of evidence. So let me bring in Jen if she's ready.
I'm
Jenny here.
ready. How are you?
Hi, Jen. Good morning. I know you'll be in and out because you got a lot of other things going on.
Good morning. Yes, I will be in and out, but I was very excited to join you today. I think this information is so relevant to the proceedings. And Kevin, this was one of the points that I know you and I discussed throughout the trial before. Why aren't they calling Karen Reed's father? Why aren't they introducing phone records? And obviously, Brennan had the same notion.
Mm-hmm. Yeah. One of the interesting things when I had been looking over things about a month ago, I mentioned this on the air, was that, so Karen called 3 times in the middle of the night. So 1:15, 4:40, and 4:42. And all 3 of those calls to her parents went unanswered. So what does that mean? Now, there was a blizzard going on, a lot of wind. Is it just people are sleeping more soundly? But I also wondered if there's a pattern there. Had she done this before? Was this something that she semi-regularly does? She gets drunk and gets angry and calls her parents in the middle of the night. So I think maybe the prosecution is trying to find out. So they've requested the records going back a month and see if they can find something in that. And because we have whatever text messages Karen sent, we already know that. We already know the calls that she made of that night because they have Karen's phone. So what do you think about that?
Yeah, no, exactly right. That's what was spelled out in this motion. They want to show whether there is any pattern or whether this was a unique and acute situation. And they think that will go towards showing her knowledge. Also, they want to use such information to possibly impeach Karen Reed's father if they feel like he isn't honest about the phone traffic that took place that night.
Mm-hmm. And I just wanted to tell people too that were here last time, and the video that once we found, we're never sure which has the best feed until it actually starts. And so I appreciate people there that be watching for us, because I've got maybe 6 or 7 usual sources, but I have a separate computer dedicated to the video feed for this once we get the hearing. So I don't expect there to be any kind of glitchiness to it, hopefully. So one of the things, I don't know if they'll go over this, Janet. I don't know if you followed this at all, but about a month ago, the defense filed a motion for D.A. Morrissey's private communications. And this was not discussed in the last hearing. So I don't know if it was tabled for this hearing, but they want all of his private communications. And they're basing that off, there was an ex parte meeting that went on between the DA and the witnesses because they were being harassed. And this was around the time when Morrissey released that special statement of his saying that the witnesses are not suspects here. I don't know. What do you think of it? This is kind of unusual, right? And I think maybe it opens the door for the prosecution to bring in some of that witness harassment. Do you think that'll come into play here?
Well, that piece is interesting because the Judge Canoni, last time ruled that unless it sort of happens organically through testimony, which they did open the door, meaning the defense, on Jen McCabe, and allowed her to say a little bit about the harassment she suffered. And
Yeah.
Allie actually also got in a few zingers
Mhm.
about,
Mhm.
in a tearful manner that she
Right.
had suffered.
Right.
But Canoni was very clear that she didn't want that to be a particular focus of the trial.
Right.
So I think that, first of all, they'll never get his personal communications, I don't believe.
Right.
But because obviously some things are attorney-client privilege. I mean, he's really the district attorney, the attorney representing the Commonwealth in this case, and his communications with potential witnesses and so forth would be protected, just like you wouldn't want anyone subpoenaing Alan Jackson's communications or Yannetti's communications as it relates to his communications with the witnesses, that he called. So it really doesn't make a lot of sense. But in some ways, I think this again has just allowed the rally cry, right? That there's illegal contact with people by Morrissey.
Mhm.
And the whole thing is just a shame that it's come to this. And I was surprised to see the motion by the defense.
There's the game within the game here, right? Which the defense has been playing this for a long time, where in theory, everything that happens is the trial and the jury is the focus of it. But we all know the reality of this. There's a public relations game here too. And I remember back in the early hearings of the spring and early summer of 2023, Alan Jackson, for example, took in the big blow up picture of John's arm when he was trying to suggest to the court that John was attacked by a dog, but he kept angling it towards the camera to the point where the judge warned him. So clearly, you're putting on a show in order to influence the public opinion, and that's the defense's game. But to some degree, the prosecution has to at least be a little bit aware of it and willing to play it too. So what I don't know if the defense motion was part of that game because I don't think, like I agree with you. I don't think they're likely to get anything. So it's just a chance to get their, but it opens the door to the prosecution to play that game and respond in this hearing today and say, this is, if you make the public aware in an official setting and so that it gets reported on local news that yes, not only were the witnesses being harassed, but they were done so at the provocation, really, at least indirectly, by the defendant herself, because she had been leaking that information to Turtle Boy and encouraging him to do that. So I don't know. Have you seen cases like that in the past where the prosecution or both sides try to play that game within the game to influence public perception?
Never like what we're seeing now. I mean, and that's because the advent of social media. Actually, I think it was Paramount Pictures that did a very interesting documentary, if you will, regarding what we're seeing now, and it's never going to change. In my opinion. In other words,
Yeah.
the effect that social media on all these platforms has, where the public starts talking and sleuths start sleuthing, right, and trying to put
Right.
hands on information. And then so much information too, Kevin, is so fake and falsified.
Yeah.
That's
Yeah.
another big problem. You can make up anything almost with AI now. You can recreate voices, you can recreate videos, you can distort them. And so now you have that weighing in. So it's not even facts anymore. I think it's just so important to keep focus, in my opinion, on the court documents and
Mhm.
on what is said by witnesses at trial and at hearings. Other than that, that's about all you can really trust.
Mhm. Right. Another friend of mine who was like you, was formerly in federal law enforcement. he's actually of the opinion he's lost so much faith in the system because of what you're talking about, that he's kind of advocating the idea of a professional jury. So you have these kind of permanent jurors, and I'm not sure that's a good idea, but I get the problem, So how do we combat this? This kind of misinformation or urban legend that gets running away with on social media? It doesn't seem like it's an easy thing to stop. Are there any solutions, any preventative things that the prosecution or the courts can do? Or
Well, I think some laws need to be changed. I've often played on my Twitter the two recordings of Aiden Carney, the blogger involved in this case, and his public rants as to his purpose. There's a big difference between communicating to try to uh, show facts in a case and try to help the public understand what's happening, because the public works. The public, it doesn't spend all their time reading documents and watching every second
right.
of trial like you and I do. And
Hmm.
so uh, for that reason, we have our platforms, and that's our purpose, right? To advocate and to help with understanding and education. But when you have somebody specifically say, my purpose is to taint the jury pool, and that is facts. That is the purpose of the swell of support for Reed as led by the blogger. When that happens, then you're looking at a whole new different animal, because it's not about education and it's not about
Hmm.
facts. It's about lies and trying to coerce a public into believing a particular set of information. And so that, I think, needs to be changed. There needs to be tighter laws. There's a big difference between our First Amendment right to free speech and harassment and intimidation, and that reaches to jury pools, I believe, as well.
I just want to respond to something in chat. You may be interested in this too, Jen, because you have a channel too. What's the name of your channel again? Geez, I already forgot. God,
That's okay. Break the case. No
Break
worries.
the Case. That's right. Break the Case with Jen Coffendever. So WV Girl says, does Kevin even pay attention to those who get memberships? And chat. I never realized it until now, and I'm not even 100% sure, but I think if you look at chat, the people that have memberships, their names are in green. That's a really good point, WV Girl. I wasn't aware of it until seeing your question. So when I don't know about Jen, like she can probably explain too. When we set up these YouTube channels, they require you, once you get monetized, to set up those membership tiers. And you couldn't. It's a requirement. So when I set it up, I just set it at the lowest levels and never really anticipated anybody using them when I was setting up the channel, and didn't really know. I still to this day do not know what to do for memberships. And but that's a good point. If people that are in green are members, were you aware of that on your channel, Jen?
So I actually, when it came to my whole channel, I didn't set it up. I had somebody do that. I just, have a lot of irons in the fire and a lot of other obligations. And YouTube is definitely not my forte. The
Mhm.
ins and outs, as you're talking about, that members
Yeah.
are green, that there's all these different tiers. But what I have tried to do and will continue to do is I want to offer special things to them. For an example, I go on personally and make certain shows just for them.
Hmm.
I think that's really important. I still haven't even figured out and don't do how you make the questions pop up. I need to start doing that, because members, they're so amazing that their loyalty, their response to the platform. And I am so appreciative, like I can't say it strong enough.
Hmm.
But my YouTube prowess is at an all-time low. Um, you know, I am
I'm
not.
still learning too. I didn't know until she said that. I was like, how do I know that someone's a member by looking just at chat? And I said, oh, maybe it's because it's green. I wasn't aware. But yeah, to quick to questions, Jen. Like you use StreamYard, I think, right? Or what do you use to
Yeah,
use StreamYard? Right?
I
Just
use Riverside or StreamYard. But what do I do?
just click it, so on the chat thing on the right, if you're in your StreamYard thing, if
Oh,
you
you just click on it.
yeah, and then you'll see, and then like, so I will have one up here now, and then you can also hide it, or yeah, it's very easy, just clicking it like that. And if you want to see the starred one, so like people that did you a solid, made a donation or something. If you go up top, you got live or you got starred. So if you click start, so what I do is a lot of times as I'm going over documents, I can't even see the chat or I'm looking at a video. So then periodically I stop and I go back to the starred and just thank the people that, made a donation or had something to say or whatever.
You know what I'm going to do, because the way I stream is I'm so focused on the topic and keeping my concentration. I
Yeah.
really don't look at chat until the end. And then at the end I look at chat. Oh, that's a sweet donation there for you. And I think what I'm going to do, how I'm going to change, because to me the members and just anybody listening in are so important. I think I'm going to give my mods full power to put people's messages up, member messages, any kind donations up, because I think that's what I need to do. My other problem is, unlike you perhaps, I have no chance of seeing close up. So now I'm like glasses, no glasses, glasses, no glasses, because my vision far away is ridiculous.
Yeah.
It's 2017, just had it tested, but up close, I can't see a thing. It's just like I'm looking at the screen right now, and you look just like a blob.
That's a good thing. That's a good thing. Don't worry.
That's what my husband says. He says, no need to get close up glasses, honey.
Did that affect? So when you run the FBI, did you have to do periodic qualification at the shooting range and things like that?
Oh, this is the crazy thing. So my vision as an FBI agent was awesome. I mean, this has only happened within the last few years, just the last couple of years. I retired in 2016, but I still shoot. But the interesting thing is that sort of mid-range, right? Your arms
Yeah.
are extended, it's several feet away. It's only my close-up vision. And so it doesn't affect that. I also am an avid tennis player. It doesn't affect that. I'm an avid golfer. I did just get a prescription, though, for the first time in my life, that addresses that mid-range, like 5 feet, 4 feet, something like that. And oh my gosh, it's so amazing how much clearer everything is.
Trying to just hold on, pull up another. I want to make sure I have things ready so I can get right into the hearing. Last time I had no problem getting in, but there was a glitchiness to it. So even though I had restarted my computer beforehand, I think what had happened was because I had a bunch of things going at the same time, it kind of clogged up the RAM memory. So I just wanted to get that ready. Okay. So the other thing.
Oh, sorry, Kevin. I was just going to say, back to your original points about this evidence, what Judge Cannoni is going to rule. It's going to be very interesting for her to look at the arguments. And at the end of the day, case law, I think, will carry the day. This is not going to be the first time that the prosecution or the defense has wanted to put in parent phone number or parent phone information in a case. So it's going to be very interesting to see how that is argued.
Yeah, it is. And we'll see. I'm not, and I don't know how much, I don't even know how much evidence that's going to really, if anything out of that is going to impact the trial. Like I said, we already have Karen's communications. So I'm will be learned from that, but it's worth pursuing and the chance that you learn something from it. Right. So,
yeah, and the Commonwealth isn't asking for a year or two worth of messages, or they're not being invasive, I don't believe. They're trying to show that this was very unusual. I think that's what they're trying to point out, that the reason she reached out was because she knew she had done something, right? That's the whole premise.
And what they're going to say in court, though, is that it could be inculpatory too. It could show that she does this every weekend,
Exactly.
So that's but I think you're right. That's what they're really looking to see and hoping to see. But we don't know. We don't know how, because it is the fact that her parents didn't answer the phone could be an indication that she does this somewhat regularly, right? When she goes out drinking and gets upset or something like that. So, I don't know. We don't know until we see it. They're only going back a month, so it's not like they're going back a year. Let's see. What other evidence are they going at today? Well, so we should maybe learn something more about the new vehicle data. Have they done that testing yet? And also, the judge has yet to make a decision on whether to postpone the trial. And that's everybody's waiting on this, right? Both sides. So I think that the delay, I'm speculating here, might be because she's waiting to see about the progress with the vehicle data testing. And so we might learn something about that today. I'm pretty sure we will.
Well, the interesting thing is she's going to have to make a decision soon. Here we are at the end of November. They only have one more month really to be preparing for trial, which some people may think seems like a lot. It is not. Trial prep is, a sometimes 20-hour a day situation. You're barely sleeping. You're really working ridiculous hours. Plus, this now is going to be over all the holidays. And so she's got to make a decision very soon because for them to have their case prepared and for the defense to have everything lined up, they're asking for this extension. She just is one not to give out extensions in this case. I think she moves this case down the road, and for obvious reasons because of everything that's transpired that we've seen that's so unusual.
Okay, we have our good people at the scene. I'm going to give you a couple of these are short clips from the scene. Don't be scared. One of these may involve a turtle.
Let's go, Hank. Woo!
Why are you supporting corruption, Mr. Brennan? Any comment? Why are you throwing away your reputation, Mr. Brennan? Any comment? No?
I don't think Hank Brennan cares what you have to say.
He ran over here quick.
So this is Special Prosecutor Hank Brennan, and that was Turtle Boy shouting questions at him that he ignored. It looks like a very small turnout, too, at this point, both sides.
I'm glad to see the small turnout. That Kevin, just the circus atmosphere of this whole case, it just takes away from the fact that John O'Keefe is dead, takes away from the fact that Karen Reed is fighting for her freedom. It just completely takes away from all of that. And so I'm glad to see a small turnout. I wish they would keep the trial date personally. I think it might help cut down the amount of people out there just because of it being during work hours, work time, and it being cold. I know they're very devoted, but that just does play a factor when you have kids in school and things going on in your life.
Well, one of the things that may have thinned out the crowd on the pink side is a decision that Karen made. They had, I'm not sure if you've seen this, Jen, but they did a big fundraiser, get-together dinner for drinks and speeches at a location in Fall River Country Club, I believe, this weekend. And there was 100 people there, all the usual content creators, the Glarer and Turtle Boy, and the big-pocketed people and people that have some supporters like, say, the Roccos and stuff like that. However, the people that have been spending all their time out front demonstrating her, some of them going back to last year when there was only, 8-9 people out there, they were not invited and they're not happy. So, for instance, Rita Lombardi, who's been very outspoken for Karen, going on Court TV, going in other documentaries and, being outspoken at rallies, being there in the early days too on this, giving up work time and stuff like that, getting into disputes with her family because of it. She was not invited and she's not happy about it. So some of those people might not be out on the streets anymore.
You bring up such a good point, and we saw it first come forward with the DEA agent, Sean, Sean from the Gulf, whatever he calls himself, coming out and saying, listen, I've been there for you. I've, quote, covered for you. I'm protecting you. We've done all this for you. And you didn't even send condolences when my brother died. You don't invite me to any of these
right.
things, and they get their feelings hurt. And I don't blame them one bit. It doesn't make any sense that they pour out all their support for Karen Reed, really a stranger, a complete stranger. I think they get so involved more as a comment toward corruption. I really believe that that's at the bottom of this. It's not Karen Reed. It's how upset they are and concerned about corruption, right?
Mhm. Yeah.
And it's terrible to see really that they mean nothing to Karen Reed.
Yeah. Yeah. I got one more clip to play. So I'm seeing the green. So I guess this maybe is the way it works. The people that are highlighted in green in chat are the members. So thank you guys. And I will try to listen to the people that are here all the time and constructively trying to help. I try to address them too, but I think they all understand there are long periods where you're not able to look at the chat window. So you're not going to see what's going on there. And, I have two great moderators, Joe and Tom Fleming. So they keep the peace and they keep the conversation constructive. But really it's that community keeps me going too, because I never had any kind of ambition to be a YouTuber, a podcaster, doing any of this kind of stuff. I'm not a person that seeks the camera. And so there are times you just like, it's not worth it. It's not worth the aggravation. But having such a good community brings you back and you say, all right, it's a fun community and I give them an excuse to hang out together. So
well said.
Where's the
Most
rest of the
people have
supporters?
jobs.
What do you?
I'm not telling you.
But you said, so you're suggesting the only kind of people down here are the ones that don't have jobs? Is that what you're saying? So why are you here then? What's your job?
It's none of your business.
I know you can't take a dig at unemployment. You know what I mean? If you're also unemployed. I'm just saying.
I'm just saying no
you
comment.
You need a new line of jokes because that one just not.
It wasn't a joke.
It doesn't land the same way. It doesn't land the same way if you are what you're making fun of. You know what I mean? So anyway, why did you suddenly you first showed up with the Food Stamp 5 in late June of 2024. Where were you before that? How come you didn't come? I've been here since May 3rd, 2023. How come you weren't coming to court dates? Just curious. No? No? Nothing? Hi, sir. How are you? What's going on? Getting in fight with Brian Albert? Oh, wow. I mean, you look a little scuffed up there. I'm just saying. But, anyway, so you guys seem talkative today. It's great to see. Are you guys coming inside the courthouse today with your leggings or whatever those are? Are you coming in with the cargo pants? I don't know. You guys should come in. You guys didn't come in last time. But maybe you will this time, because we'd love to have you in there. We'd love to have you here, the facts being presented. Do you guys think the trial's going to be moved to April? No? They're not fun. Oh my God. They're so not fun. Anyway, you guys have a great day. Justice for John O'Keefe. Justice for Karen Reed. And let's put those filthy, lying McAlberts in jail where they belong, right? Am I right? Michael Morrissey going down. That guy going.
What do you think, Jen?
Just like the people out there, no comment. Don't feed the monster.
Well, this is one of our good people at the scene sending the videos. So I want to play what she sends me, and she's doing a great job out there. And
absolutely.
I think one of the things that she's trying to, one of the things you could have said to Turtle Boy there, she said, she's like, "Where are you? Where's your side? Most of these people have jobs," and that's true. But I think another thing is that most of the people or many of the people, and I'm just speculating, but in the Pink Army, this has become their social life, and it's more important to them because of that. Whereas I think more of the people on the blue side are they only out there to try to make the family feel welcoming because of the O'Keefe family, because of the harassment that they were experiencing at the hands of that Pink Army. And that's really the only reason they're out there, is to support the family. So it's a little different for them,
Yeah, I definitely agree. This isn't part of this, groundswell movement against what is perceived as corruption, and that she's, been falsely accused. This isn't what that's about. They truly are out there just to support John O'Keefe's family. And,
Right.
and it's interesting. They've always been more quiet. The O'Keefe family stays quiet, and they support through their actions, not through their tirades. Kevin, I am going to fade off for my conference call in my real time. And I know this hearing's starting soon. I'll come back after my conference call.
Thank you very much for being here, Jen. We'll see you later.
All right. Bye-bye.
Bye. Hold on once. Oh, got the wrong. So I just hold on 1 second, guys, while I hook up the other computer. All right. It makes me go through these all kinds of hoops to get logged in. All right, I am in. So I'm in on 2 computers now, and looks like we're just about ready to go to the hearing anyways, I think. What are you guys finding a good feed on the hearing yet? Looks like it's not live yet, but keep watching, guys. It's getting close. All right, let me hold on. It should be in a second. Stand by a couple of seconds.
If possible, yes, that would be great.
Sorry, guys. Can you hear me now? Okay. So I don't see Alan Jackson here. There's Yannetti. There's Attorney Little on the right. We got the new Special Prosecutor Brennan Lally in the middle, and then the Special Prosecutor. I'm sorry, the Assistant Prosecutor McLaughlin on the end. She's kind of usually quiet in court, but she writes really brilliant motions. You can kind of tell when it's written by her. It has a certain kind of almost literary flair to it. Really respect the way she describes things. If it's her, my understanding is her that writes those. It looks to be at this time a little bit less animosity between Yannetti and Brennan than there was between Lally and Yannetti. But obviously, give it time to build up. Lally had a lot of reason to be frustrated. These things get personal. One of the things that I'm finding, coming to believe, is that in order to be a defense attorney, so you got most of your lawyers are probably doing corporate law and things like that. And you have prosecutors and you have defense attorneys. But your defense attorney, you can make a lot of money off of certain clients, but those are probably fairly hard to come by. And you spend your days with a lot of people that are really kind of scum of the earth. It's a hard way to make an existence sometimes, knowing you have to go and defend those kind of people every day. And I think that they tend to, just as a coping mechanism, convince themselves that a lot of these people are actually, a lot of their clients are innocent. And so I do believe, now I'm not making a determination as to whether Karen is factually innocent or guilty, but I'm saying I believe that her attorneys, certainly Yannetti, believes that she's innocent. Now, maybe that's an act of self-convincing as a coping mechanism. We don't know. There's no way of knowing that. But I do believe that that's something that goes on with defense attorneys. I'm getting that sense from talking to a lot of them on the side that they do kind of, especially if you're a good person, you don't want to think of yourself, or even if you have just an image of yourself as a good person, it's hard to go home at night knowing you've been defending some pretty horrible people. So I think they become conditioned over time to convince themselves, if that makes sense. And there's really often no way to know what is going on in someone's head, like, say, Karen Reed right now, because she knows the camera's on and there's a performative aspect to it. Is she confident? Is she nervous? We don't know. You can look for little signs, I think, in those moments when she doesn't think the camera's on her. But in moments like this, she knows people are just studying her and the news teams are studying her through the footage. And so she wants to, she's probably even prepared by her attorneys to look a certain way. And be interested to see if we had an attorney here today to tell us what they would advise their clients, but I'm expecting that they would probably want their client to look confident, because if you're innocent, you look confident. But yes, someone said smirking, that's a fine line. If you look smirking, it looks kind of obnoxious. So I don't know. So for the people before that pointed out to me that, or indirectly, that maybe the way for me to know that when I look at chat that someone is actual member of the site is if they're shaded green. If that's the case, I do want to try to pay attention more, but I have never been able to figure out a way to give back to the people that are supporting us as members. And I'm definitely willing to do private shows. I just didn't know if there'd be enough interest in it, or if it's not like, see, Turtle Boy can do a private show, and because his audience is so large, he's going to have several hundred people there. That's my regular show. So for a private show, I don't want to do it, and there's only 5 of us there. So I don't know. You guys can give me, you guys can let me know if you think that that's worthwhile. If you want me to do a private show, really the best way would be if we could all get in a room together and have a drink and meet each other. That would be the best way. Jennifer said she would be interested in a private show, so we'll find a way to we'll definitely do that. We'll definitely figure out, maybe we'll do one a week or something like that, and figure out the best time to do it. I haven't even set up a schedule in terms of like Turtle Boy does. I think normally every Saturday and Tuesday are his shows, and then he does a members only show on Thursday. And I know there's a huge advantage in having a regular schedule. I just have not been able to do that. It's just there's so much else going on, and I'm kind of like, when there's some breaking news that I get, I do a show. Lately, there's been a lot of shows because there's been a lot of news. But you never know when that stuff is going to come in. It could be as simple as going over motions or going over an article. So I think actually Karen McCormick from True Crime and Some Wine is going to come on this week with me, and we're going to go over Tuesday's article, Tuesday Gazette. Tuesday Gazette has another good article up. So me and Karen discussed that yesterday. So we're going to pick a day and do that. Sailboat says most of us are just becoming members to support you. Thank you. And I do believe that's the case. People are just trying to support the expenses of the channel. And thank you. I appreciate it. And we're meeting the expenses, by the way. So don't feel like I'm asking you to donate something. The expenses are about $150 a month, and we're covering that. So not to worry. I think we took in $400 last month. So I try to find ways to use the surplus money to find some way to give back to the community. It might end up being lame. Last year, I spent it on bringing some flyers down and to Dedham, and by bringing a film crew down there to try to film the crowd and stuff like that. It didn't really work out well. It ended up being a waste of all that surplus money. But we'll bank it, and we'll try to figure out a way to support the cause or support whatever. And just to be clear, the cause is not to get anybody convicted of something. The cause is truth and justice. The cause is defending the victim and his family. The cause is defending witnesses that are being falsely accused of being part of a conspiracy. That's the cause. And I think a side cause too is as me and Jen talked about, most people have way more interesting lives than me, and they don't have time to read all the documents and listen to all the testimony. So what they rely on are people like me who do have time and to try to bring both sides kind of analysis to it. That doesn't mean 100% neutral, because over time you're weighing the evidence. So I'm not just reporting it to you. I am going to give you some analysis of it. But that analysis is always going to continue to be objective and both sides. And so if I'm doing it right, there are going to be times when people on both sides get frustrated with me. And that's certainly been the case. That has definitely been the case. But that tells me that I'm doing it right. If one side is always happy with me, I'm probably not doing it right. You know, because it's easy for people to it's human nature to, once you are on a side, to start seeing every piece of evidence that comes out through that filter in a way that it's supporting your side, confirmation bias. And I think my job is to try to avoid doing that and do the best I can. Now, I am not someone with law enforcement experience. I am not a lawyer. So I'm bringing that kind of everyday regular person view of it, which many or most of us here are in the same boat. And so, but that doesn't mean we as citizens can't get to answers on that, because we go and we have time to research it. Now, maybe I have a little bit more time to research it. And the other thing is we have to be respectful of expertise, whether it's law enforcement or legal or whatever. But we shouldn't get too overwhelmed by that too, because we're seeing in these cases, and I'm seeing personally, and a lot of the people that I talk to, a lot of really mistakes by lawyers, by people in law enforcement. It's so they're human beings too.
Quiet, please. Yay. Golf process have any business before the office, heavenly penalties. Justice in the golf course of area court, in Flint County. Your name, your time shall be heard. God save the Commonwealth of Massachusetts. School is now open. You may be seated.
There's 22117, the Commonwealth versus Karen Reed. Can I come to identify themselves, please?
Thank you. Good morning, Your Honor. Hank Brennan, on behalf of the Commonwealth, along with me is Attorney Adam Lally and also Attorney Laura Floyd.
Good morning, Mr. Brennan. Good morning, Mr. Lally. Good morning, Ms. McCarter.
Good morning, Your Honor. Elizabeth Little appearing on behalf of defendant Karen Reed.
Good morning, Ms. Little.
And good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right.
Also, thank you. Mr. Jackson appears to be in Zoom.
Okay, we can't see him though, Jim?
We can't see you, is that okay?
All right, good morning, Mr. Jackson. All right, we have several motions this morning. Let's start with motion for admission pro hac vici that you filed. And Mr. Unetti, I know these are freely granted, but I have a question about here. So you say good cause exists to grant this motion because Mr. Alessi has specialized skill and knowledge in representing defendants in matters of this nature. What do you mean?
Mr. Alessi is somebody with decades of experience in the courtroom, both on an appellate level and on a trial level. He has handled many criminal cases over his career. I have actually consulted with him on a criminal matter. I know of no better trial attorney in the country than Robert Alessi. There are aspects of our defense that would greatly benefit from his expertise. I'd rather not go into the specifics in terms of the division of labor on our team, but I'd ask the court to, take judicial notice that with his background, with his experience, he is going to add value to this team and protect my client's constitutional rights.
Okay, so he's not a criminal lawyer, but he's a lawyer who does some criminal work. I just don't understand what you mean by representing defendants in
Right.
matters of this nature.
Right, of this criminal nature. He has represented criminal defendants throughout his career.
Okay, all right, thank you. All right, so let's go on to the discovery motions. We'll start with the requested records of Mr. Reed. I'll hear you, Mr. Brennan.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly, the Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion similarly, the Commonwealth has filed motions simply for the call log for 30 days for Janet Reed. The Commonwealth has a burden with two of these charges, one being second-degree murder, to show the element of knowledge. It is the government's burden to show that Miss Reed knew she struck John O'Keefe. Second-degree murder, as the court is aware, is a person committing an intentional act with a strong, plain likelihood of death. In a second-degree murder charge, there are a number of different theories that a Commonwealth can progress. It could be an intention to hit somebody, or it could be that somebody intentionally drove, struck somebody, left them behind, and didn't render aid knowing that there's a strong potential likelihood of death. When Miss Reed knew that she struck John O'Keefe is a critical issue in this case. Simply because the government has significant evidence outside of phone records to support and to convince that Miss Reed knew she hit John O'Keefe when she did, the government's entitled to the full value of their proof. The records for 30 days begin with that aspect of William Reed's records. Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She calls both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Miss Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew that she had left him behind. The 30-day period is an attempt to protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there are no other calls in that 30-day period from Miss Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
No. There were 2 search warrants from Miss Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided by the defense. I can provide clear copies. The 2 search warrants from Miss Reed's phone are from a period of January 28, 6 p.m. to January 29th at 6 p.m.
Okay,
And the other one is January 28th, 9:30 to January 29th, 5:30.
okay.
And so they're not in Miss Reed's records. I am not looking to see any of the other numbers that the family called, friends, family, whatever their purpose is. I'm not looking to even see it. I want to see and demonstrate there's an absence of phone calls between Miss Reed and her parents the 30 days prior to when she drove into John O'Keefe. Now, it would help the defense. They want to expand that to 6 months or a year. I'm agreeable. Because if there was phone calls at 1:30 in the morning, I would not argue the inference that it was remarkable. That would be an unfair inference. But in the absence of any other calls, it is terribly remarkable that she is panicked calling her parents at 1:30 in the morning. And here's why it's important. The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced a drill and drilled it into his brain to create bleeding so it wouldn't swell, or they could have cracked his cranium. Now, certainly he would have suffered significant impairment, but I expect the government is pursuing a witness, and my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe. And so if Miss Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father. Nothing else am I interested in. The second part is the 24-hour period with William Reed. The 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to that story that will be explored at trial. The time of the phone calls to Miss Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, in your first discussions, my motion leaves off the S in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it'll be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny his daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e. Mr. O'Keefe, is critical to the government's case. And so we cannot rely just on Miss Reed's phone for a couple of reasons. Number one, phone records often show different communications. Sometimes calls or hang-ups don't register on a phone, and so they could be different. Secondly, I've learned that Miss Reed's phone was sent to a taint team, and the Commonwealth does not and should not know what, if anything, was redacted from Miss Reed's records. The idea of sending it to a taint team, I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the benefit of the history. But what I do know is we cannot say that the records from Miss Reed are a full accounting of her records, and so that Mr. Reed's records stand separately from Miss Reed's records. Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information and phone registers. I note the defense point of collateral information. I don't even want to see it. I just want to see if there's communication between Miss Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor. Your Honor, the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022. And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his daughter. But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th from not one, but two separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy so that the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't
Right.
prohibit the Commonwealth from calling him.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at CF McCarthy's, and he wasn't present at the waterfall on January 29th, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone, using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night. The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. The Commonwealth has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all four elements of Lampron were met. Here, the Commonwealth has failed to meet its burden to meet even a single prong of that four-part test. In regards to the burden that they have to establish that the records are evidentiary and relevant, the Commonwealth in its affidavit set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's characterization of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, "I believe I hit something," was the Chevy Traverse, which the court knows. We have a video of her hitting a Chevy Traverse that morning. The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon. The Commonwealth is well aware of that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th. The Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29th, 2022 is necessary to show that it would be unusual for Karen to have called her father. And the Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m. So the frequency at which Ms. Reed called her father's cell phone in the middle of the night has no relevance whatsoever. As to the second element of Lampron, here the Commonwealth's affidavit is facially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial. And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources. Element 3 of Lampron was also not addressed in the Commonwealth's affidavit. It's facially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its affidavit, the Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, "The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed were made sometime after defendant struck the victim and before the victim was found." Your Honor, that statement is provably false. Ms. Reed's phone records established conclusively that she did not call her father on January 29th until 6:32 a.m. after she found her boyfriend incapacitated on Brian Albert's front lawn. Therefore, the requested records should not be turned over to the Commonwealth. This is a broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate use of Rule 17. This unsupported request is overbroad and must be denied. Thank you.
All right, thank you. Did you want to respond in any way, Mr. Brennan, or move on?
Very briefly.
Okay.
In between the multiple accusations of bad faith, what the attorney says that is most telling is they don't know who answered the phone. That's a harbinger to trial. The prosecution doesn't know who answered the phone when Karen Reed called her parents or her mother's phone at 1:43 a.m. No, the Commonwealth doesn't. And so we have to prepare that when Mr. Reed takes the stand, we have phone records demonstrating all of his phone calls and that he had control of that phone, so there can't be a suggestion somebody else was handling the phone. Or, on the other hand, if the position is going to be that Janet Reed answered the phone, the father's phone, or that William Reed answered the mother's phone, then we'll call both witnesses at trial and we'll sort it out. But it is that very nature of suggesting confusion or uncertainty that the government is obligated to try to prevent that trial. And we're being diligent, we're being studious, and we're going to be prepared. And these records will help us do that. That is the exact point and reason why we need these records. Thank you.
All right, did you want to respond at all, Ms. Little?
Well, I think the Commonwealth actually brought up the issue of, it tried to basically say, I need the Verizon records because Karen's phone records don't establish that Mr. Reed answered the phone. But all I'm saying is that neither do the Verizon records. So there is no additional information the Commonwealth is going to obtain by digging through Mr. Reed's private cell phone information.
Okay. All right, so we sort of overlapped a little bit with Mrs. Reed, Janet Reed's records. Do you want to be heard further on that, Mr. Brennan?
No, I believe the court understands my argument unless the court has any questions for me.
I don't, but thank you. Ms. Little, is there anything specific to Mrs. Reed that you want to address?
Yes, Your Honor. Again, I just emphasize that the affidavit in support of the request for Ms. Reed's phone records is plainly insufficient. They haven't addressed numerous elements of land crime. That alone is a basis to deny the request, and it's not permissive. It's mandatory that the court deny the request. Land crime is very clear. If you don't meet a factual showing in the affidavit in support of your Rule 17 motion, then the motion must be denied. 3 of the elements were not even addressed in that motion. So on that basis, we request that the court deny the motion.
Okay, thank you. All right, so we will move along now. Both of those are under advisement. We'll move along now to it's paper number 405, Commonwealth's renewed motion for all audio recordings, notes, emails, text messages, voicemails, and the possession of Gretchen Voss and or Metro Corp. I do have an opposition that I received this morning in an affidavit from Robert Birch, attorney Robert Birch, who I think is present in court. So, Jim, did he file an appearance too?
He has previously filed.
And we'll use that in this case as well. All right, so Ms. Little, you did not intend to argue that, right?
No, Your Honor.
Okay, so Mr. Brennan, I'll hear you, and then Mr. Birch, I'll hear you.
The Commonwealth has filed a motion to reconsider in part, and in addition, there is a request for information that was not requested before by the Commonwealth. Your Honor made a ruling in the past to turn over portions of the materials, and in that ruling, it invited the Commonwealth after review to renew or reconsider the motion or the extent of the motion. I've had an opportunity to listen to the hearing. I've had an opportunity to review all of the pleadings relative to the Boston Magazine and Ms. Voss information. And I've had the benefit of observing numerous other statements that have been made by Ms. Reed publicly. And I've been able to contrast and compare the statements made to Ms. Voss as well as the statements made to a number of other media organizations, including Dateline 2020, Vanity Fair. And after a review of all those materials, it is clear that there is significant materials that were not turned over to the Commonwealth that are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed, have a copy for the court if the court pleases.
Yeah, that would be helpful.
And there were 2 different interviews that were turned over. One was represented at the last hearing, that it was 4 hours long. The Commonwealth received 3 hours and 19 minutes. It's missing, not a little bit, a significant portion of that hearing, 40 minutes. The second interview was represented in the audio recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes. So the majority of that interview was not provided. And so there wasn't just a few redactions, they were significant. In addition, which is notable, and you can glean this from the transcripts, is that there wasn't just a few interruptions. Mr. Yannetti is noted on the transcript 37 times, Attorney Little 33 times, and Attorney Jackson 33 times. And so there are significant interruptions and redactions in both recordings. These redactions in the recordings are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change, sometimes subtle, sometimes not so. There is a change in the statement by Ms. Reed. And so it is clear that there is an inference that in those redacted portions, there is conversation or consultation or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements. That bears directly on the credibility of the witness. Because be mindful, all of her statements are admissible. All of them. They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of the defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so it's not only what she says in the interview, it is what is missing in the redactions. Now, certainly, there may be discussions in those redactions that involve her attorneys and Ms. Voss. But none of that is protected. None of that is protected. A defendant enjoys many privileges, but when an accused decides to cast aside their privileges, they don't get to add their own layer of protection. There's absolutely no basis in our jurisprudence for a defendant to be able to do that. They enjoy a Fifth Amendment privilege as they should. A defendant is presumed innocent. But when they cast it aside, it's at their own peril. They have an attorney-client privilege. But when they obviate the attorney-client privilege by speaking in front of a third party that's not part of the prosecution team, that privilege no longer exists. It dies. And there is no reporter privilege in Massachusetts. And so what has happened in this interview is that we have 3 attorneys, a defendant, and a reporter having a free reign of interview, and then later deciding what parts of the interview they want the public to hear, what parts of the interview they want the Commonwealth to have possession of. They don't have, respectfully, that choice or that power or that discretion. They can contract with each other, have their own side agreements and what they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where those redacted portions are critical to understanding why the story at times changes after the redactions. And so I think of it this way. If Ms. Voss was called to testify by the Commonwealth at trial, and we have her on the stand, and I was to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss. I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall, and it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law, to protect statements that the defendant or their attorneys made that they don't want the Commonwealth to learn about, is just wishful thinking. That's all it is. And, you know, I'm not oblivious to the fact that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none. Arguably, all 3 of the attorneys are witnesses as well. Now, Commonwealth is not heavy-handed. The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put an attorney in an uncomfortable position. But they're all witnesses to a substantive statement, many of them admissions of guilt, contradictions, all of them, in the most respectful way to pursue those, the strongest way, the fairest way to pursue those, with moderation, is to get them from Emily Voss in the interview that exists. Now, in the pleadings, I received the response this morning. I didn't get to read the entire thing. I have no objection to it. But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on 2 propositions. Number 1, Commonwealth versus Doe, promulgation. Those cases, when you read them, deal with confidential informants. Not confidential information or what someone wants to be confidential. It's not even confidential. She said it, she said it. There's a difference, and Your Honor pointed out in that hearing. Could you give me a case that talks about confidential information as it does confidential informants? And respectfully, there was no case to be produced because there is none. The cases are dissimilar because they deal with trying to get to a confidential source that may expose a source that never may not be used at trial anyways, because it's based on hearsay or there's no factual basis for it. This is not a confidential informant. The defense chose a strategy, a very strategic strategy, to sell their story and disseminate to the public, potential jury pool, in a way they thought best fit their needs. And they've done this continually. And although an attorney cannot produce evidence to the public or encourage it, it violates the rules of professional responsibility. They cannot have a statement that is meant to reach the potential jury. A defendant can. The Commonwealth does not resent that Ms. Reed has made statements to all of these different outlets. She's entitled to, she's presumed innocent. She can make all the statements she wants. But when she does, there is a consequence for that. And they now bear the consequence of these statements that have been made. And so, since it is not a confidential informant, it's a very public, identified person, it's Ms. Reed herself, the argument of Doe and promulgation has no merit. I know Your Honor was troubled by the affidavit of Ms. Voss and that she was afraid for her safety. And from a personal level, I empathize. In this case, firsthand, I have never seen anything like this, where witnesses have to fear walking out of their car. It's repugnant. It undermines the fabric of the judicial system. But Ms. Voss isn't alone, and I have empathy for her. Almost every witness, civilian witness for the Commonwealth, has sustained similar or far more egregious abuses. It is awful to think the level of harassment and intimidation that someone must suffer because they're simply a witness in a case. And my empathy is to Ms. Voss, but to every other witness in this case. She is in no different position. It does not impede the progress of the Commonwealth. It does not impede the fact-finding mission. It's unfair. It shouldn't happen. Something should happen as a result, but it has no bearing on the analysis in this case. It just doesn't. And so there is a ton of conversation that has been redacted arbitrarily by parties that want to use what's in their best interest, but cover up what doesn't help them. The Commonwealth is entitled to it, and we're seeking it and we want it. We want all the redactions in the first and second interview. Over 75% of the second interview is redacted. We want the notes from the third interview. Ms. Voss is a witness. She wasn't at the scene. She didn't see Ms. Reed drive into John O'Keefe and leave him in the snow, but she's a witness to substantive statements, her statements, admissions, confessions. And those notes evidence the statements of Ms. Reed. They're clearly discoverable. And the email or text message and phone call, again, statements of the defendant. Ms. Voss, reporter or not, is a witness in this case to some of the most crucial damning evidence in this case. We're entitled to it. We take no exception for it. Thank you.
All right, thank you. Mr. Birch.
Thank you, Your Honor. Robert Birch for Metro Court and Gretchen Voss. I've been here before, Your Honor, on a remarkably similar motion. And Your Honor at that time made a Solomonic decision and said that 2 audio tapes minus attorney dialogue and off-the-record comments would have to be produced. And the one-on-one off-the-record interview between Gretchen Voss and Ms. Reed did not have to be produced. And the Commonwealth has simply made no persuasive showing as to why the decision should be any different now. The Commonwealth makes much of the fact that there are heavy redactions on the it was a 1-hour interview according to the affidavit of Gretchen Voss, which had been submitted with our original opposition to the first motion. So it wasn't quite as lopsided as counsel is intimating. But in any event, the reason for the redactions is that the Commonwealth made a point in its original motion that it was not seeking anything but the defendant's statements, that it did not want colloquy of attorneys. It did not seek what the attorneys were saying. And it said that over and over in its original motion. Now it's suddenly changing the rules and says, oops, we've decided we want those after all.
Didn't I leave that open for them though? Didn't I leave that open for them to come back even at the first trial? To come back and request it upon review of the first
I'm sorry, I didn't quite.
I left that open for the Commonwealth to come back the first time even, right? The first trial. And we have here now a new trial. We have different attorneys presumed with today's motion on both sides. So why are we focusing on what they requested first and what's different than now?
Well, Your Honor, I think the burden on the press is, it's still the prosecution seeking information from the press. They got a certain amount of it. They're now asking for more of it. And the question is, why do they need that more? They had made a determination at one time that in order to be fully prepared for trial, they only needed a certain amount. And they only did not need attorney's colloquy. And now they're saying the attorney's colloquy is central to what they need. They can't have it both ways.
Okay, go ahead.
The change of subject from one before and after a colloquy, he says, bears on the credibility of the defendant. But if the defendant contradicts herself in the course of an interview with Gretchen Voss, I fail to see how that has the impact of serving as grist for impeachment at trial. And one has to wonder whether this motion is really an effort to keep Ms. Voss off the stand and off from reporting, because she, in fact, has suffered, as Your Honor noted at the earlier hearing, from harassment. And Your Honor noted in your order that the disclosure of the material sought would require her to divulge information that will hinder her ability as a journalist to assure sources that she will keep certain information confidential. That's what she averred. And her affidavit also details the harassment she's endured since the publication of her article and her fear that if compelled to turn over the requested material, in particular the handwritten notes of the off-the-record interview, she'll be exposing herself to further harassment and endangering the safety of herself and her family. And Your Honor wrote, given the extraordinary public attention and scrutiny given to this case, and her fears for her own safety and that of her family are no doubt warranted. And in light of the concerns set forth in her affidavit, the court concludes that the asserted damage to the free flow of information is more than speculative or theoretical. You said it was a close call, but given making the division, what I call the Solomonic division of providing some and limiting others, seemed to make sense. So what are they seeking now that they didn't have before? Well, in addition to seeking the redacted portions of the interviews, which Metro Corporation's counsel undertook time and expense to redact them to accord with what the subpoena as approved, what the subpoena as issued had asked for. They're asking now for the handwritten notes of Ms. Voss of a one-on-one off-the-record interview that she had with no attorneys present. Those are handwritten notes. There's no audio tape. They are partial notes. They are they are they're phrases. They're not complete thoughts. They're more jog memory sorts of telegraphic mentions. So it seems likely that if required to turn over these notes, which essentially represent the work product of the journalist and her personality as expressed in her, what she takes from the interview. If forced to produce that, it's very likely the next step is that the Commonwealth is going to want to depose her or call her a trial in order to explain those notes and interpret them. And that's going to take us down yet one more rabbit hole in this case that this already had so many. It would also have the effect, maybe the calculated effect, of preventing Ms. Voss from covering the trial, because if she is called as a witness, she is not permitted to sit in the courtroom for the proceedings.
So she did attend the last trial, right?
She did,
On a
because she
daily
was not on
basis?
the witness list.
Right, on a daily basis?
I believe so, yes.
Okay.
Every day? Yes.
Okay, thank you. And that was Ms. Voss who just responded to you?
I'm sorry.
That was Ms. Voss who just responded to you, yes, correct?
Yes.
Okay, thank you.
And finally, the Commonwealth asks for the first time for texts between Ms. Reed and Ms. Voss. And we do have texts. They are, the manner in which they get forwarded from an iPhone is that they come out without the name of the speaker. You can sort of guess at the name of the speaker, but you don't see the name of the speaker. You also don't see the date and time of the communication. I'd ask that we're willing to turn those over. They were not off the record, but I ask that we be able to turn them over in that form, which is the form we have them in, rather than go to whatever expense and trouble to replicate a different format.
Okay,
And that's all I have.
all right. Thank you very much. Mr. Brennan, I'll give you a chance to respond, but I do have a question for you based on Mr. Birch's opposition. If you've got the opposition with you, Mr. Brennan?
I have a copy.
Okay. So what I'm going to ask you to respond to is on page 5. First full paragraph, the paragraph begins that this litigation, but the sentence is, in other words, the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging admissions by Reed or reveals that she was not entirely forthright in her unsworn press interviews with Voss. What do you say about that? You touched upon it when you started your argument today about inconsistencies. What's your argument to that specific?
Having received this morning, having not had an opportunity to read it, could I just have one moment to read it in context?
Sure.
Thank you. This posits two separate ideas, the way I interpret it. The first is the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging omissions by Reed. The audio provided thus far contains many damaging admissions to Reed. In her first interview with Gretchen Voss, She talks about when she dropped John off and where she dropped him off. It's noticeable in many, many interviews, the story changes. At one point, she has them going to the side door of the house. In fact, in 3 of the interviews, he's going to the side door of the house. In a further interview, she says he went to the front door of the house. It's not subtle. There's a reason. The stories and the versions given by Ms. Reed evolve in time. Coincidentally, they evolve sometimes with the production of Discovery. And so I am not suggesting for a second that there are no damaging statements by Ms. Reed. In fact, there are confessions, there are admissions, and there are contradictions based on later statements given. And so all I can simply say is that is not the Commonwealth's position. That is stated wrongly. Also, or it reveals that she was not entirely forthright in her unsworn press interviews with Voss. Well, we're entitled to take her statements with Ms. Voss and compare them to all the other statements she made. 2020, Vanity Fair, Dateline, and others. And so the question isn't whether her statement to Voss or Ms. Voss is accurate. It is in comparison to other statements. Is it accurate? And we know that it's not. There are many instances where she has given different statements between versions. Also internally, in Ms. Voss's interview, as I mentioned, there are statements, redaction, a return, and a different statement. For example, she was only sipping at the waterfall, which would suggest further drinking. And then after a redaction and interruption, she's sipping water at the waterfall, as incredulous as that may be. And so clearly something happened during that redaction that changed the admission to drinking alcohol, which is part of this case, to something of water. And so I think that the claim in this motion really has no relevance to the analysis. It's not on point. The reason I said there was a 2-hour interview, and I'll accept that I'm wrong, is when I listened to the FTR tape, counsel respectfully said it was a 2-hour interview. And that's where I got my information from, not Ms. Voss's affidavit. So it may have been a 1-hour interview, which still leaves us with 1/3 of the interview, 2/3 redacted. That is significant. The Commonwealth comes back, we're entitled to come back when we want, if we have a good faith basis and if the court invites us. We come back now after I've had a chance to actually listen to 6 or the 4 hours of interview, or you add them up, 3 hours and 40 minutes of interview. I've studied them, I've listened to them many times. I've ordered transcripts, I've perused the transcripts, I've compared the two. I've compared them to all the other statements. So time has now made these much more relevant than they maybe initially thought. I can't speak for the Commonwealth at that point. We're entitled to the full force of our proof. We don't have to just take some. We don't have to take a fraction. Just because it's inconvenient or uncomfortable for parties, the government is entitled to the full force of their proof. And representing the people of this Commonwealth, I am pursuing the full force of our proof in every aspect because we're entitled to it. It is notable in the FTR hearing that counsel for Ms. Voss and for the publication said that the 3rd interview they discussed, and the parties, meaning the defense attorneys, the defendant, the defense attorney, the defendant, and Ms. Voss could decide to use that material. It wasn't that it was precluded or no one could ever see it. It's only if it helped them. And so he said that they agreed that if they wanted to, they could use that material. They just decided not to. Because they decided not to use incriminating information in their story doesn't give them the power to decide who does and when they do. So we're entitled to the full force of our proof, and we're going to pursue it. We're entitled to all of these records, all this information. There is no legal argument against it, none.
All right, thank you. So I know, Ms. Little, I asked if you wanted to say anything. I just give you that opportunity. Was there anything you wanted to add? Okay. All right, so that is taken under advisement. And now we have 3 more motions. I understand Mr. Albano is here, who will be filing an appearance if on all 3 or arguing all 3. But So Mr. Albano, you can come forward, sir. And Mr. Brennan, do you want to argue each one of these individually? It appears I did get an opposition this morning that goes to service, which pertains to all three, but do you have different arguments, a little bit different on each?
I do.
Okay, so Mr. Albano, do you want to be heard after each argument, or do you want to just be heard at the end of the three? There are three motions. FXT TV, Boston 25, WCVB TV, Hearst Television Incorporated and ABC, and NBC 10 Boston. Okay, thank you. And again, on these, Ms. Little, you don't expect to argue? No, you're right. Okay. If you do change your mind, just stand up and let me know. No, that's fine. Okay. All right, I will hear you. Why don't we start with the FXT TV, Boston 25, it's paper number 400.
As has been discussed, Fox 25 and its employees conducted an interview of William and Janet Reed. I've quoted on subsection 5 some of the language from that interview. And during my quote, it says, during your first discussion with Karen. It should say, during your first discussions with Karen. There's an S left off. Nevertheless, during your first discussions with Karen, did you believe she may have hit John?
Did she believe?
Yes.
Okay, I thought you said, did you believe?
Then I misspoke. My apologies. Did she believe she may have hit John? William Reed responded, no, she felt she struck something. She said, Dad, I think I struck something. I said, what do you mean, right? This was in the hospital, right? She says, I remember, all right, backing up and hitting something. I've had the benefit of at least looking at the phone records that are available for Karen Reed and seeing there was a phone conversation that morning to William Reed's phone. That phone conversation is before Karen Reed is admitted to the hospital. And so it is by inference in the back of a police car at the scene. Now there's some ambiguity during your first discussions. The operative word as I see it is first. It is a particularly remarkable statement to make that in the throes of realizing the great tragedy that's unfolding with John O'Keefe lying in the snow dying, that the comment of thinking that they hit supposedly now another car in a driveway hours earlier would be the topic of conversation at that point. There is not a fair inference that would be the subject matter. It is not a fair conclusion that a person would be so fixated on a mere nudging of another car that caused no damage hours earlier when we're dealing with the potential loss of life. And so I think it is reasonable to infer that that was actually not the complete statement. The conversation lasted on that morning for over a minute, and there was certainly conversations after. And so the defendant's father has, as he's entitled to, utilized media to try to sell a story to help his daughter. And during that airing, it is clear and obvious that not the entire conversation with William Reed has been provided. During these stories, oftentimes there is summaries to progress the episode much quicker. And so all of his statements, which may not be a lot, but all the statements to that employee of Fox 25 who did the interview should be discoverable so that this statement can be put into context. Some of the doctrine of completeness. We should know what the entirety of the conversation, the interview was, so that we can assess this statement and draw the proper inferences from it. It is expected that William Reed very likely will be a witness at trial. He will be asked about this conversation. He may be asked about what else he had said. It will be impossible at trial then to try to produce the other statements that he has made to this network or this employee. And so the Commonwealth or anybody who would be questioning him would be just simply left to the whim of his answer. And I'm not satisfied to do that. I do not think there is any protection. He is not a defendant. There is no privilege. And so there is no reason to protect this information so that it can fairly be brought into context so that when he is cross-examined, if there is evidence of impeachment or cooperation, that both sides are aware and know of the substance of that material. And that is the reason we request the pleading in number 400 for the Fox 25 footage that was not aired.
Okay. Have you had a chance to read Mr. Albano's opposition this morning? It's not very long.
I haven't, but I can say Mr. Albano kindly called me. He outlined the issues in an email. He made this a much more streamlined and agreeable process. And so I credit him with his effort. I don't need to read his response. I'll appreciate what he says.
Okay.
My short interaction with him, his total candor, I have no hesitation what he says in his representations. I might disagree, but I don't need to read his pleading.
Okay.
There are two, NBC and ABC. Your Honor would allow me to start with NBC because I think we can streamline that. NBC 10 has agreed to give promo materials in their possession. I've not only spoke to Mr. Albano, but I've spoke to the attorney for the subsidiaries that we also had subpoenaed. And they told me that as subsidiaries, they do not have possession of the materials of the parent company. And I received letters from the attorneys stating as much. So as it pertains to NBC 10, the position is that one of the subsidiaries is going to send us promotional materials. And as far as service on the parent company, I don't think the Commonwealth succeeded, despite the fact that we made numerous efforts in hand, mail, UPS to a number of subsidiaries. I don't think we're satisfied, so I do not want to ask the court to progress that.
Okay. Do you have a timeline on when you'll get this material?
The promotional materials?
Yes.
They said they were putting them together. I did not ask for a timeline.
Okay.
The promotional materials are a very small fragment. It's I've only seen one clip aired. I don't know what else they have, but it should not take them long.
Okay. I don't have a paper number. Jim, do you have the paper number on NBC 10? Here, just, you know what, Jimmy, you can give it to me after. I don't have that paper number or the other one. All right, so do you want to?
427, Your Honor.
What is 427? All right, so do you want to move on to CVB TV?
Yes.
Okay.
WCVB TV has been served, and they've notified that they're not in possession of the materials, have no control over the parent company, and they are not part of the company. And so I no longer am asking WCVB TV to produce these materials. Instead, in the alternative, we have subpoenaed the registered agent in Massachusetts, the registered agent for the parent company. They have been properly served. If we look at the Secretary of Commonwealth of Massachusetts Business Entity Summary website, not only do they have a principal place of business in New York, but they also have, as a registered agent, a local address, 84 State Street. So our position relative to the ABC materials is that ABC has been properly served locally. Unlike NBC, that did not have a local registered agent that we could find, or perhaps does not have one, ABC does. ABC does business in Massachusetts. In fact, these interviews with Ms. Reed may have taken place in Massachusetts. I don't know. But they have roots in Massachusetts in that they do business here. They have a local registered agent. And the reason to have a registered agent is to accept service, provide notice in cases of objections, and to provide materials. It is done routinely in civil cases when a registered agent is notified, they are then obligated to get materials even if the REM exists in a different place. Their position is that the REM exists in New York. That is irrelevant to the assessment in this case. To suggest that somehow the physical property being another jurisdiction is not in the control or purview of the local registered agent would just be enacting a shell game where local or companies could pick jurisdictions they find most favorable, do business in outside jurisdictions, and avoid the consequences of that. That, I don't believe, is how the law is set up. As a registered agent, they are the same as the company. They just have a local contact to accept all types of service, communications, and responsibility. And so our position on ABC as far as service is concerned is they've been served through the registered agent, and therefore whatever materials exist, regardless if they're in Massachusetts or in New York, they are required to obtain them and they're required to produce them.
Okay, so Mr. Albano disagrees with you, and on the third page of his memo under paragraph 5, so I will give you the opportunity to read that.
Okay.
Under that 5th paragraph. Do you want to address the substance of your motion regarding ABC?
I do. Much like other recorded statements, we see from the Nightline in the 2020 interviews, there are a number of public statements that Ms. Reed has made to a national audience that don't reconcile with other statements she has made at other times. I've given you the example of not knowing which door she supposedly saw John Keefe go into. There is differences in her stories and versions about where she was that night after she left the O'Keefe house. There is a number of examples where the different versions given contradict each other. And so although they're all substantive statements, they're all admissions and confessions, they still have a value in the fact that they contradict each other. And so the episode that is aired, 2020 in Nightline, you hear oftentimes the author of the story, not even the interviewer, the author saying, and we spoke to the person, and then this is what happened, and then they go to a clip of an actual interview. The summary by the author is not admissible. It can't be used substantively. It can't be used to impeach Ms. Reed should she testify. It is hearsay. It's inadmissible. And so these summaries have a genesis somewhere. There's a reason why the reporter is asking certain questions, or more importantly, the author is summarizing testimony, oftentimes inconsistent with other versions. And so that means that there is footage from which the author has gleaned this information. There's either footage or there's a conversation with Ms. Reed. And so those are statements, not unsimilar to or dissimilar to Ms. Voss interviewing here. Those are statements of a defendant, which are substantive evidence for their full value. And so that footage we're entitled to see. There's nothing that should protect it. We should have the opportunity to review all of the statements and also put the ones in context that were broadcast to the nation. And that's the substance of why we want it. I'll have to take a moment to look at the response.
Okay. Mr. Albano, we'll give him a couple of minutes just to read it. Sure. Does this have a docket number yet? Paragraph 5, it's on page 3. The pages aren't numbered. Actually, you should start at 4. Or why don't you read the whole thing, Mr. Brown? Why don't you have a seat and read it?
I appreciate that. Thank you.
Paul, do you want me to step off or stay here? We'll stay here.
May I?
Sure.
Thank you. Your Honor, our position is we disagree with that proposition. We are not trying to subpoena another state witness. We're trying to subpoena materials from a company, and although the company has a principal place of business in another state, by having a registered agent, we believe that gives us jurisdiction. I can understand the company would like to remove this to New York. There is a reporter's privilege in New York that is profound. It is not so in Massachusetts. In Massachusetts, there is none. And so I see why it is the company's preference for us to go to New York, to use New York law, but I don't believe that's the case. I believe as a registered agent that we have an entitlement to subpoena them here, and we follow Massachusetts law. There are a couple of cases in the memorandum that I'm not aware of. I think it would be prudent for me to research and jeopardize, and because I think I have an obligation to do that. I would ask you to allow me to have a day to provide a brief supplement. It's not to re-argue the case or the merits of the case, but if there is adverse case law, I want to recognize and acknowledge it. But not.
I'll give you that opportunity, but I will hear from Mr. Albano today since he's here.
Of course. But our position is, although they would like us to go to New York, we can submit it in Massachusetts to the registered agent, and that entitles us to the material. So that's the way we've done it.
Okay.
Thank you.
All right, Mr. Albano.
Thank you, Your Honor. The two cases I cited, just to be clear, they address the Uniform Act, which Your Honor dealt with last year. They don't address the specific issue the Commonwealth has raised, which is, okay, you have a registered agent, we serve the registered agent, does that trump the Uniform Act? I have to say, I did not find a case that dealt directly or even indirectly with that. But here's why I believe the service issue does not override the Uniform Act. First of all, we're dealing with a statute. Statute talks about a witness in another state. There's no dispute that ABC is a foreign corporation with a principal place of business in New York. Now, the analogous areas I thought of was, okay, let's say someone wanted to sue ABC in this court. Yes, they could serve them through their registered agent, but that wouldn't change the domicile or citizenship of ABC. If there were a diverse plaintiff and a diverse defendant, it would still be removable. It doesn't make them residents of Massachusetts, or for example, subject to taxes in Massachusetts. It's simply a way to make service a process, but the plain language of the Uniform Act and the policy underlying it is not overridden by service. The two cases that I did cite, one is the grand jury case out of Rhode, I think it started in Rhode Island, SJC case. And that just generally explains how this Uniform Act works. You go to the Superior Court here, you get an order, you travel to New York, and New York decides whether the subpoena will issue. The second case, which I think was in re contempt or something like that, was the SJC saying, by the way, the receiving court, and in that case, Massachusetts was the receiving court, we don't just rubber stamp these if there's a privilege issue in our state. And so that's what tells us that if this court issues us an order under the Uniform Act, Commonwealth travels to New York, the New York court then decides, does it enforce it, or does the privilege that exists in New York, is that privilege dispositive? And that's what we say is the right answer here, that yeah, they have a point, they can make service, but it doesn't override the statutory requirements of the Uniform Act. And as to the other, I think things are pretty much under control with the other motions. WBTS, which is NBC 10, has previously published those promotion ads for the show, and they say, well, no, they've already been out, fine, we'll get you copies, and that's what I've been told by the client as well. WFXT, which unlike ABC is here, does have some raw footage. The station's position is that if Your Honor decides under the Rule 17 standard that yes, this footage is relevant enough to come within the Rule 17 scope, then WFXT will produce that information. I do expect it will already be published before, so the unpublished I do expect won't be unpublished anymore, so they'll probably be in a position where they're simply turning over published information, not unpublished information. But I do think that, so I think WBTS and WFXT are effectively resolved.
Okay. Do you want to respond, Mr. Ryan? Thank you, Mr. Albano.
I'd just like to give one example that I'm sure you've thought of, and we see it often in tort law. If U-Haul is a foreign company, I don't know where it's located, but if the principal place of business is in Texas, and there's an accident here in Massachusetts, and I'm requesting as part of my litigation corporate materials, I do not have to follow the Uniform Act to go to Texas or litigate in Texas under Texas law. Because the company operates also in Massachusetts, as does ABC. I can sue in Massachusetts, and that company, this registered agent, is obligated to get those materials for me. Otherwise, a company could simply hide in whatever state is most beneficial to them, make it impossible to litigate or obtain materials, and there would be subterfuge throughout the entire process. We have jurisdiction here because they operate here, because they have a registered agent here. It does not matter where their corporate or their headquarters is. Thank you.
All right, any follow-up, Mr. Albano? Sure.
My first point is that we're dealing with a statute here, and the statute says this is how it works when you have an out-of-state witness in a criminal case. So that's different than civil discovery. The second thing I'd say is ABC has a registered agent here, but WCVB is owned and operated by Hearst Corporation. Hearst Corporation is totally separate from ABC. That's why neither of them could produce the documents in this case. So I just want to be clear that the presence of an ABC affiliate here, owned by an entirely separate company, Hearst, does not mean that ABC is here in Massachusetts. They're a foreign company that has an agent for service process. They don't have offices and the like here in Massachusetts. Are they doing business here in the sense of transmitting ABC news programs through affiliates? I don't argue that. What I'm arguing is there's not the service, the fact that they're subject to service does not override the requirements of the statute.
Is there a distinction between obtaining records and obtaining a person's presence to testify?
The SJC has said in the grand jury case, the first case I cited, that the same procedures apply for documents as for witnesses.
Okay.
Thank you.
All right, thank you. So those are all the Rule 17 motions we have. Am I missing anything? Those are all the Rule 17 motions. All right, so we have some housekeeping matters that I just wanted to check on. I still have the motion to continue under advisement. I need to see how we progress with it. The Commonwealth's notice regarding the testing of the telematics system, where do we stand with that, Mr. Brennan? I know you had said you told them that Thanksgiving rather than Christmas to highlight big holidays, but where are we?
I did, and if I could have had it done quicker, I would have got somebody else. I have spoken to my expert numerous times. He has coordinated with the defense expert. They are heading to Texas on December 2nd
Okay.
On December 2nd, they're going to test all of the chips, and there's an SD card that we expect has information on it. And then they're both scheduled to travel back to Massachusetts for December 5th.
Okay.
And they're going to do what's called the chip on, where they take the chips, the SD card, they reapply it to the boards, they put it back in the modules, and they put it in the actual car because there's different software which will give it even a more fulsome reading. And so after the December 5th event is done, I've asked my expert if I could have all results within a week. I have an uncertain response, promised to do his best, which really doesn't give a lot of meaning, but my hope is within 7 to 10 days.
Okay, thank you. And I don't know, Ms. Little or Mr. Jackson, if you have the answer to this, the transcripts of the sidebar conferences. Ms. Little, do you have any scheduling idea on when those will be available?
Yes, Your Honor, I do believe that Mr. Jackson had spoken with the court reporter and emailed the clerk's office with an update. It's going to be a little bit longer than initially expected. One of the reporters had sort of like a family emergency and needed some additional time. And so I believe, and I'll have Mr. Jackson correct me if I'm wrong, but I believe she needed until about 6 weeks to get the sidebar conference.
6 weeks from the November 13th date?
6 weeks from about a week after the November 13th date. Thank you, Your Honor.
Thank you. All right. Mr. Jackson, did you want to speak?
Your Honor, Ms. Little addressed the court's specific question about the transcripts, and that's as accurate a bit of information as I have, so I'll submit on that.
All right, thank you. All right, that is it for today. The Commonwealth is going to file a response to the discovery of communications in the possession, custody, and control of the Commonwealth by 11/27, right?
Yes. Your Honor, I provided the defense this morning with a response to their motion. We'll file it with the court. It is a request that they made that is very labor and time consuming, but a very important task that I've been involved with. I expended many, many hours, and I need many more. We do have, or I have produced, or I have a production that I'd like to produce to the defense. I've shown them a protective order this morning to see if they were agreeable. I do not want to speak for them. If there is a protective order, I can turn over the first production that I produced, and there is more to come.
All right, any objection to the protective order? I have not seen this document, obviously, nor the proposed order.
Right, there are a couple of issues related to this motion in addition to the protective order that I'd like to address with the court that I've briefly discussed with Mr. Brennan.
All right, I haven't read this yet, so I won't know what you're talking about.
So I believe you have read our motion, right? The motion that
I read your motion, I have.
Right, so it's just in relation to the motion, Judge.
All right.
So, Your Honor, generally speaking, we do not have an objection to a protective order as long as it is issued without prejudice, which I believe Mr. Brennan is in agreement with.
All right, is there one here? Was there a proposed protective order?
I have it right here, Your Honor. Mr. Brennan provided this to us this morning.
Yeah.
So I have not reviewed that, Your Honor, but I'm asking that the contents be allowed to be shared with the entire defense team, including our attorneys, our interns, and our client. I don't believe Mr. Brennan has an objection to that, but that would be our request with regard to the protective order, with the understanding that we could come back before the court and revisit that if we deem it appropriate.
Is there any objection to the sharing with the
There's no
defense
objection
team?
to the parties they would like to share it with, and I understand it's without prejudice.
Okay.
Yes, and with regard to the motion itself, Your Honor, I had come prepared with an argument for the allowance of the motion. Given Mr. Brennan's, the work that he's done in terms of trying to gather this material and get it to us along with the protective order, I assume that there's no general objection to the motion, so I don't need to be heard in that regard, assuming the court would allow the motion. But I would raise an issue for the court, actually two issues. One is that we were informed this morning that Mr. Brennan has gone through Mr. Morrissey's cell phone. Apparently there is one work cell phone and one personal cell phone. Obviously the personal cell phone becomes relevant because he used the personal email address to make an ex parte communication with the court. One concern that we have is that we were told this morning that with regard to Mr. Morrissey's text messages, not emails, but text messages, apparently they're somehow remarkably set to auto-delete after 30 days. That obviously raises some questions for us, maybe the subject of a future motion, but more immediately, the concern is every day that passes, we're losing text messages from 30 days prior. So, you know, through today, I believe.
They were preserved, Mr. Brennan?
I've been preserving them since I started the task last week. I'll continue to preserve them.
All right, so that.
Yes, that deals with that issue. So the only remaining issue, Your Honor, is with regard to the searches that Mr. Brennan ordered conducted or conducted himself, he had searched for all emails sent from Michael Morrissey's iCloud personal email to any emails that had a JUD in the suffix of the email address.
Okay. The significance of that is?
The significance is that would supposedly capture any ex parte communications with members of the judiciary or the clerk's office, and I appreciate that effort. However, we think we assert that it's insufficient. We believe that searches should be done of his iCloud email for the name Reed, spelled R-E-A-D correctly, or Reed R-E-E-D, which is how Mr. Morrissey typed it in his ex parte communication with the court. We don't know if he did that for the purpose of avoiding a FOIA request or if he just misspelled my client's name. But we believe there should be a search for both of those spellings. And in addition, we also believe there should be a search of his email address, the personal email address, for the names of the relevant witnesses, and we can give the court a list, for the names of all judges who have sat on this case, in terms of, you know, is there an attempt to communicate with a judge on some type of personal email account, like he used a personal email account. And then also we believe there should be a search for any clerk's office employees for the same reason, both at Stoughton District Court where this case originated and this court as well. We have obviously reason not to trust Mr. Morrissey in light of his actions using this personal email account to make an ex parte communication. And we'd ask that a more thorough search be done for these types of communications.
All right, so why don't you continue to talk with Mr. Brennan and we can have a hearing on this motion if there's anything that you still need on December 12th when we're back here for the Daubert hearing.
That's fair enough. Thank you.
Does that make sense, Mr. Brennan?
It does. I've taken extensive steps to do this myself to accommodate the defense in the most broadest fashion. And I'm going to do that. If they want to discuss how I can accommodate them, I'll do my best.
Okay. All right. So we will see everyone December 12th. So when do you expect to get me any written material you want me to have prior to the Daubert hearing?
Yeah.
Yes.
Your Honor, we drafted the planning and hearing motion. I need to review it. I'd like to get it to you by the end of the week.
That's great. I expect to be here at the end of the week, so that's great.
Thank you.
And your response by next week, Ms. Giannetti? Ms. Little?
Yes, if we could have it at least a week, Your Honor.
Okay, so I'll give you 10 days,
Thank you.
as long as that gets me before the 12th.
No problem.
All right.
Yes, Your Honor.
Yeah, if I can get it, as soon as you can get it. All right. Anything
May I-
else? Yes.
I'm sorry to interrupt.
That's okay.
May I inquire if the protective order is going to be signed by the defense?
Are you going to sign the protective order, Ms. Giannetti?
I expect I will, without prejudice.
I have the materials. I'll just wait.
Okay. All right, so if you sign it, then I'll endorse it, Ms. Giannetti. You had it, right? Ms. Little gave it to us just now?
I believe we just gave our copy to the court.
Yes.
All right, so this is the one that needs to be signed and I'll endorse it. Do you want to take a look at it?
Yes.
Mr. Brennan, I know you have an electronic signature. I'd like you to sign this as well since you're here.
Yes, Your Honor.
Just sign that and I will endorse it. Okay, anything else?
No, thank you, Your Honor.
No, thank you, Your Honor.
All right, thank you, and I appreciate counsel and the third-party record holders coming in today.
12:12, 9 a.m. All rise for the court, please.
You are muted. Goodbye.
That guy next to the tall guy in the back looks like the guy from The Office. I forget that character's name. He's off camera now. Okay, a lot to go over here. This was actually, I know these things can be tedious. It's the law, but there was a lot of interesting stuff happening here today. I actually, and you guys can update me a little bit in chat. One part I missed, I had a phone call coming in. I got a little bit when they discussed the tech stream. I mean, the new chip off on the vehicle data. I didn't hear exactly, have they done the chip off yet? And they're waiting for the analysis, or are they still trying to schedule the chip off? I missed that part. So if I can find a way to rewind this here, because it was late, I'll do that in a moment, but I don't see a rewind option on this yet. So not sure how I'm going to do that if I can now. Audio up. Well, there's nothing going on. So I turned the audio off inside the court because you can't hear anything. I mean, you just hear people leaving. You're not really hearing anything. So let's start with the end. And please, chip off scheduled on December 2nd. Thank you. Hoping for justice. I appreciate it. Okay, that was the part that I didn't see. Okay. Keep in mind, I am not a lawyer. Please. I'm not just throwing that out there. I mean, legitimately, I'm not a lawyer. But so the protective order at the end, my understanding. So the defense had filed a motion a month ago looking for a transcript of the sidebars during the trial. And in addition to Morrissey's that's the district attorney, his private communications, both emails and phone calls, whatever data could be had on that. And so the protective order is basically as Prosecutor Brennan is trying to comply with this and put together the information, the protective order is to add a level of security that will not be leaked. So as we know, this defense team leaks what they want to Turtle Boy in order to, for their media war. But they want this protective order would be to make sure that nothing gets out. I thought that the prosecution might even say you're not allowed to share it with your client, but they didn't ask for. The prosecution might ask for that, but they didn't ask for that. So maybe so there's probably no legal basis for asking for it, and that's probably why Prosecutor Brennan didn't do it. Should we call him? I'm going to refer to him as Prosecutor Brennan. I don't want to keep saying special prosecutor. That's adding way too many syllables. So let's go back. I took notes, so we'll go in order. All right. So they're bringing in a new lawyer who has a specialty in trial law. I think we saw a little bit of him today. And I just also want to say too, sometimes I'm critical of Lally, but look, as good as Hank Brennan is, and he's supposed to be supposedly one of the best, and I'm sure he is. But there were moments that Lally did just as well as Hank did today too. So I think we could almost look at this trial maybe in this way. The first trial, Lally did the commendable and excellent job of debunking the conspiracy theory. We haven't heard any of the jurors referring to the conspiracy theory being something that was on their mind. So Turtle Boy interviewed 2 jurors. One of them was on the fence, but ended up switching from not guilty to guilty on manslaughter, and the other one was acquittal on all 3. But none of them really were talking about the conspiracy theory. So I think Lally did a very good job overall of debunking the conspiracy theory. What he failed to do was prove the state's case. And that may be a part of that was the overwhelming burden that was on. I'm not saying he had no help at all, but he really was short-staffed and was not given the resources that he needed to do that. So in the second trial, so let's call this trial part 2, really, the state is now going to be able to do that. They're going to do a much better job of doing that. And I think that, let's see what we got going on. All right, so we'll probably just take this down. I just want to see if it lets me rewind because well, I guess I don't have to rewind to that part because you guys just gave me the answer. So, all right, so we'll just close this off. So I think that, honestly, had Lally been giving, and I'm glad they brought in Brennan, but had Lally been given another bite at the apple, he would have done a much better job. Just more time and resources, learning from the mistakes of the first trial. So I don't want to be too hard on Lally. I think there were moments that Lally did very, very well in his position up there, especially going over things like the wall files and stuff like that. So there were blunders. We are right to be criticized. We are right to criticize the overall presentation of the state's case. They had a lot of evidence. They didn't get a conviction. So let's start there. That we're right to be critical about that. And I have been very critical in the past because I believe the strategy that they used was flawed. But let's not just make it seem like this guy completely botched it. I mean, he did a lot of things very, very well in the trial and deserves a lot of credit for that. And it was just, look at how many lawyers, highly experienced lawyers that the defense team is bringing in. He didn't have that benefit. And also, it's a lot easier for a defense team to just bring out things that look suspicious because they don't have to prove their side. They just have to create reasonable doubt. So it takes a lot more work for the other side to have to debunk that stuff. It really does take. So if the defense managed to find a version of Celebrite that said that the search was made at 2:27, they just have to present that. That's easy. It's a lot more work to have to go and debunk that. And that's just the nature of the beast. So Lally really did have an enormous task. So I also want to say too, So I think Hank did a good job today, and I think it's interesting to watch this. Even no matter how experienced or how good of a trial lawyer you are, I do think there's a moment of getting your stride. So I watched a Supreme Judicial Court hearing a month or so ago that Kevin Mahoney was in, unrelated to this case. But it was interesting to watch. Very experienced lawyer like Kevin, and he has about 15 minutes to make his case. And in the first 3 or 4 minutes, he hadn't quite found his feet yet. And then he was warming up. And then after the Supreme Judicial jurors asked him some questions, he finally really found his feet and kind of hit it out of the park. So I think we're seeing a little of that here with Hank Brennan. He was warming up as he went and getting more comfortable and more confident. And then a few minutes into it, really started picking up speed and doing a very good job. So I think we're going to see him do a great job in the trial. So let's see. The first issue was the phones of Mr. and Mr. Reed. And, there are interesting elements here. What new information are you expecting to get out of that? Brennan made the point that because a taint team was involved, so once they found privileged communications on Karen's phone, they stopped searching it, and that phone goes to a taint team. And so what Brennan is suggesting here is that because of that process, they can't be sure that something wasn't removed by the taint team that shouldn't have been. So they can't be 100% sure about all of Karen's communications. I don't know how compelling an argument that is, but I think another interesting aspect of the going after the Reed's communications is that information could be exculpatory or even inculpatory. Like I said before, if it shows that Karen is making those kind of late night drunken calls to her parents when she's upset on other occasions, then it looks somewhat inculpatory. That it doesn't look unusual here. I found it odd that Attorney Little for the defense kept trying to say the first call was at 6:30, which she was really saying. They always play with words. The first call that they actually connected on and they spoke to each other, but there were 3 calls that were unanswered in the morning. So I don't, but obviously the judge is not fooled by that. But this is why a lot of this stuff is meant for public consumption. So they're hoping, so they'll slant things like that whenever they can. So Brennan he really captured the essence of what the second degree battle is here. Technically, the very fact that Karen put the car in reverse at high speed when there could have been people around satisfies the requirement of second degree, the reckless endangerment clause of it. But realistically, it's difficult to get a jury to want to give someone such a harsh sentence as second degree just based on that alone. So what they really want to do is show some actual malicious intent on her part. And malicious intent, obviously, is if she decided to, if she knew John was there and tried to scare him or tried to hurt him or something like that. Yeah, obviously. But it also would mean if at some point later on she understood what had happened and failed to act, failed to call 911 to get emergency help for John. So this is something that you're seeing Brennan talk about now. And for those of you who've watched this channel, we've been talking about it for a long time. Brennan said that there is what he described as significant evidence that she knew. Now, that doesn't mean there's evidence that she knew in that moment. It just means at some point she knew that she probably had struck John and she failed to act. So, we have to go over what that evidence is. There's her statements, there's her actions, there's the fact that she called her parents, and that's what they're focusing on here. So she called her parents at 1:15, a call that went unanswered. But is that normal? If it's unusual to call your elderly parents at that time, why? What predicated that? Were you in a panic because you had just done something? So, we don't know that, and you have to read into it. But this stuff is it's not by itself, but as part of a pattern, it is something that the prosecution is going to want the jurors to weigh. They're saying that there's evidence that she knew that she struck John with her vehicle. Again, the same thing. When did she know it? But as long as she knew that, so if she knew that before they found John and failed to act, that will be evidence of second degree. It's also a problem if even if she didn't know it until after they found John, but then she tried to cover her tracks. Of course, I believe, again, I'm no lawyer, but that would be an obstruction charge, not second degree on something like that. And that's not something that she's currently charged with. Brennan talked about an inference from the calls. He said they're not asking for any texts. And what the defense is worried about is this is a fishing expedition to see. So, for instance, let's say Karen had called her parents at 1:15 and did in some way talk to them. Now, she didn't. There's no evidence she did. But then right after that, her father called Karen's brother or called a lawyer or something like that. I don't know. Is it a fishing expedition looking for anything like that? Is there something to show that her father was awake? So let's say they look at the calls and the father is making other calls to other people in the early hours of the morning before he talked to Karen. What would that mean? Why wasn't he taking the calls from Karen? But again, there's no evidence that they have Karen's phone. So if Karen called, for example, somebody else, and then that person called her parents, that Mr. Reed would be smart enough to maybe not take the call from Karen. But again, there's no evidence of that. But it would be, what would it tell us, though, if the Reeds were making calls, say at 1:30, 2 o'clock, 3 o'clock in the morning? That would show they were awake. So why didn't they take the calls from Karen? I don't expect that to really lead to anything, but it's worth exploring all these avenues if you can explore them. It sounds like they're going to bring, he described it as a witness. So I think they're going to, that will talk about how John could have been saved had he been, had first responders got there within a couple of hours. Now, he didn't say they're going to bring in an expert. He described it as a witness. So I'm assuming that's one of the doctors is going to come in and say, pretty good chance, somewhat of a chance, that had they got to John within a couple of hours, he could have been saved. And the interesting thing is they're going to ask questions. This is important. This should have been done in the first trial. There's no excuse for not doing this in the first trial. When they had those doctors on the stand, you can talk about techniques that could have been done. So the injuries to John that were when he struck his head, the state is saying he struck his head on the ground. That then he got a bunch of fractures that led to swelling of the brain. Because the brain is encased inside the skull, that swelling causes more blood vessels to burst all the way around the brain and eventually leads to that swelling in the face that produced the raccoon eyes. It's a known effect. But if you have someone in the hospital and you're seeing that swelling, and this is a common thing that they deal with if somebody's fallen or other types of head injuries, you drill into the skull to release the pressure. And so it's going to be very important to ask the doctor, the one that already testified, what would you do in that situation if someone came into your emergency room and they had that kind of swelling? And so the jury is going to see that had she acted or let's just say, had John been discovered, then yes, he could have been saved. So you link that to the possibility that she knew. And I don't know to what degree that will be established. I don't believe, listen, I really try to both sides this all the time. And that, like I said earlier, if I'm doing my job right, everybody's frustrated me at some point or another. And that, it isn't always fun to be like that, but that's my job. And I don't believe that the voicemails indicated that she had any knowledge of what she had done. Now, those voicemails, I'm not talking about the 523 voicemails. I'm talking about the 5 or so voicemails that happened starting at 12:37 and ending at 1:18. Those voicemails where she's angry, she thinks John's cheating on her, she's threatening to go back to her parents' house, knowing that might make John come home because he doesn't want to leave his nephew and niece alone. But there's no indication that she knew she was in an accident. And it's also, those voicemails are somewhat of an indication that she didn't know, because there's you don't see any evidence of her trying to cover her tracks by saying, okay, John, I'll see you when you get home. I left some food in the fridge for you or whatever. There's nothing like that. So those voicemails don't tend to show that that Karen knew. However, the calls to her parents are partial indication that she knew maybe something had happened. And that first call, I think, was around 1:15. But then when things really seem to change, so she says she took a nap, say from 1:30 to 4:30. Now, the lack of phone activity on her phone during that period does tend to confirm that she took a nap. And the phone records of Karen were given to the jury, but they were not made public. We only know the indications that we were given in trial through testimony by Tully. So I believe that there's no activity on the phone at that time, but I don't know for sure. If there is no activity, it does tend to confirm that she took a nap. But something seems to have really dramatically changed after she woke up. So at 4:38, which is probably the first sign that she's awake that we know of, she called John. She left no message, and obviously there was no answer. So that's the indication that she's awake. And over the next 15 minutes, well, she calls her parents twice, and they don't answer. Then she's calling Katie Camarano. John had been drinking that night with Katie's husband, Mike, I believe. And Katie was working third shift as a nurse in a hospital till she was awake. And so Karen called her to try to see if she could talk to her husband and find out if he had any idea where John was. Then the niece testified that she heard Karen screaming basically in the hallway, saying something's happened to John. John's been hit by a plow, something like that. Now, the niece's testimony was not public, was not on film. So we don't know for sure. All we can go by is the reporters were in the room, and I've gone over all the articles. They don't give a very lengthy description of what that testimony was. So, but we do know that the niece testified that Karen was saying stuff that something had happened to John. So that's a solid piece of evidence that something had really changed. For some reason, before Karen goes to sleep, she thinks John's cheating on her and she's mad. But then afterwards, she thinks something has happened to John. And what new evidence has she learned that made her think that? Another piece of evidence of that is when she called Kerry Roberts at 5 a.m., she said, John's dead, Kerry, and she slammed the phone. And then she called Kerry back immediately afterwards and said, something's happened to John. I think maybe he's been hit by a plow. Those are really strange things to say. Those are really strange things to say. You go to sleep and you think the guy's at an after-hours party just drinking more and he's cheating on you, maybe cheating on you. He's never cheated on her before, but she's jealous. And then you wake up and now you think something's happened. And it's only 4:30, so it's a few hours later. So John could still just be at that party drinking. Why wouldn't be? Or he could have ended up on somebody else's couch, right? So I think Jen is about to be, let me give her a minute to make sure she's ready, and we'll bring Jen Coffennever back in. So something had changed after Karen had woke up, and there's evidence of that. So is that the evidence that Brennan is talking about? I would guess yes. Let's see if Jen is ready. Jen, you here?
Yes, I am. How are you? Yes, okay. I agree with you. To get straight.
Were you able to see some of that get caught up in the hearing?
Yes, I was able to see about 30, 40 minutes of it.
Okay. Any observations?
Oh my gosh, I just love Brennan. He's to the point. He knows exactly what he's talking about. He knows the law very, very well. I think he's going to be just very well received.
Hmm. I think a jury's going to respond well to him too. He's not flamboyant like Alan Jackson, and I don't think a jury wants that in a prosecutor. I think that worked to Lally's advantage. I do think the jury trusted Adam Lally. Um, I don't think they thought he was shady or trying to, railroad somebody. I just don't think they felt the state proved their case about what happened to John beyond a reasonable doubt.
Well, and I would argue, I think there was just jury nullification.
Could
When
be.
you have one of the jurors show up in a pink dress, I know she wasn't a voting member, but
Yeah.
that said a lot to me.
Right. And we know that the dismissed juror was out drinking in bars during the trial, night before testimony, and wasted, and telling people in multiple bars, and I've talked to people that were with her, that she's a turtle rider and she's going to acquit Karen, which means this person was willing to deceive her way onto the jury and then every day on the stand raise her hand and lie under oath when they ask her if she's been following this in the media. Disturbing.
It's disturbing, and I don't think there's any way to get around it unless this is tried someplace else. And I understand the legal issues there in Massachusetts and how difficult, if it can even be achieved. I know there's too many issues and it probably won't move, but there's going to be no way not to have issues with the jury if it stays where it's at. That's my belief.
There are ways to do a better job on that, and I believe they are. So they're much more aware of it now. You can reflect it with the voir dire of the jurors, question them to find out more. Have they participated in social media and in a both sides kind of way? Because so I'm not in that county, but if I was to be called for a jury like this, I would have to say, yeah, I followed this case very closely. I have formed opinions, and no, I'm not eligible to be on this jury. I would have to say that. So it should be done in a both sides kind of way, and I'm sure it will.
It does need to be done in both sides because I agree with you. If you have a preconceived belief as to the guilt or innocence of Karen Read, you can't be on the jury, period. So I agree, both sides. And I just don't think they're going to find people there that aren't familiar with the case and have seen so much. I just don't think it's possible, but maybe it is.
So Brennan did a good job explaining how Mr. Reed goes on the media and says how in the hospital, Karen backed into something. And I thought it was a really good point that Brennan made. Why would Karen be fixated on something at that time, on something that happened that led to no damage to those vehicles, which I think they'll be able to show much better this time in court. So it definitely suggests, if she made that statement, that would suggest consciousness of guilt. But there's also reasons to question why Mr. Reed was saying that and whether she actually made that statement, because at the time Mr. Reed said that was the exact same time that they were trying to push the idea that Karen had backed into John's Traverse, and they had leaked that video to Court TV. Now, I don't know if Brennan is aware of this, but according to Natalie, Karen was unaware of that she backed into it. It was actually, again, according to Natalie, I don't know but Natalie's cousin, Kelly Reed, who's an attorney but not assigned to this case, who's been working very closely with her, was going over the discovery material, and she's the one that noticed that Karen had backed into the Traverse. So they should put her on the stand and see if that's a fact, because that would show that why is Mr. Reed saying that when they weren't even aware of it?
Exactly. And I don't think she was aware of it. And I don't think that's what she was referring to. I mean, when you watch that video, the snow doesn't even fall from the Traverse. It's literally such a tap. And this was an important point that was made at the hospital. Remember, Karen Reed was, hysterical. She was out of control. She had to be taken under medical advisement, if you will, and committed, if you will, for a short period of time due to her hysteria. And yet she made a comment. You would never make a comment about, bumper tapping a traverse in the driveway. This was far more significant. And I think anyone who listens to the facts understands that.
And why would Mr. Reed, like, he's a very intelligent man, very educated man, and he would have worked with Karen's attorneys for some time about what he was going to say in his TV appearance. So to me, I've always looked into that. Like, this was a very deliberative thing for him to say. Why would he say it? It's, I think it's something we have to consider there, right?
Yeah, I think it was because that's at the time they were really working toward the idea of this was an accident. This
Yeah.
wasn't on purpose. This was just a tragic accident. And I think that's what the point was, right? She knew she might have hit something. She backed into something, and then they've just spun it with the new information about the traverse that
Right.
was well after.
Well, I think what they were trying, that was at the time when they were trying to portray this idea that Karen was factually innocent and the damage to the taillight happened in the driveway, which they might regret that now, because I think it's going to be disproved that was even possible based on the speed of the vehicle and the way the bumpers matched up, the backs of the vehicles matched up. There was no damage found to the traverse. No pieces visibly fell into the snow below, which we would have seen it. So I think they're going to regret that. And I think it's great that the prosecution is going to expose that by putting him on the stand,
I think it's so important. All of us who followed this closely, we saw why isn't Reed being called, meaning Reed's father, Karen Reed's father. But another point is, and I think the reason he was never called earlier was because Adam Lally had his hands full. And as I've always said with this case was initially viewed by law enforcement as a simple domestic violence hit and run situation. It was never viewed in any other way based on the facts that they had before them. And even prosecuting, you never think, oh my gosh, I've got to send his clothes in to check for canine DNA. All the things they had to do that is so far beyond what you would ever normally do because of how the snowball started going down the hill.
I always wish they would have x-rayed John as part of the autopsy, because then we'd know what happened. Like, I believe they'll find small fractures in the elbow, but the ship has sailed. So
yeah, unless he's exhumed.
Yeah, we don't want to see that, but we don't want to put the family through that.
No, I agree. But what I did miss, I saw the arguments, but I didn't see the rulings. I'm assuming she's tabled it and we'll get back.
Yeah. And big thing here, though, this is not a ruling, but it wasn't discussed, and all indications seem to be that she is not going to postpone this trial. So there was at one point about something that they were trying to prepare to be ready for trial. So no, I think she's just not going to do it. That's her, whatever her reasons are. She didn't want to do it last spring, and she's not going to do it here.
Well, I'll tell you why it does make sense. Although we have a brand new prosecutor, and I think that's very unfair to Brennan, but why it does make some sense is this case has been around now for years. Everybody has had the discovery now for years. We've already gone through trial. So I see why she doesn't want to postpone it.
Yeah.
It would have been almost a year. Not quite, but they've had months and months and months.
Yeah.
After they prepared, both sides.
I mean, I would hope that the judge considers it, because one advantage is even just towards the presentation with the juries. There were a lot of aspects last year that trial was not well run. And I don't know to what degree it's the fault of the judge, but they weren't on the same page at the beginning as to how they were going to tag evidence. And so you had these hours worth of delay every time one side wanted to submit documents or evidence. Just ridiculous to put the jury through that. There has to be a way to streamline that better. And so in this case, now maybe they've already learned how to do that better here, but you have the prosecution is definitely going to bring in experts, and possibly the defense too, new experts. if all this is, if they're given enough time to prepare all of this, it's going to run like a more succinct case, I think. I don't know. Does that make sense?
Yeah, it does make sense. I know what you're talking about. There were a lot of efficiency problems with marking and tagging of the evidence.
Yeah.
Again, I think a lot of the reason there were issues is because, and I'll just reiterate, Adam Lally was everything to this case. He was the cross-examiner, he was the presenter, he was, doing the exhibits. I know he had a little bit of help, but very little. So I think with this team expanding a little bit, it's going to help. It'll be interesting to see. By the way, I haven't heard you comment yet about the new attorney, making attorney number 5, added to the Reed side of the equation.
So what I know about him is just we learned today that he supposedly is an excellent trial attorney. So he's just been brought in for that, I guess. They gave Little a chance to, I think Little's going to be a fine attorney. I think she is a fine attorney, but having that courtroom presence to be confident and go up there in a high profile trial, that just grows with experience. So they're giving her a little bit more experience today. But they want to bring in an experienced trial lawyer for whatever reason.
When I see Little, though, I don't know if you gleaned this, her voice was shaking. I mean, she seems so nervous in the presenting side of things. And it's not that I don't think she's a brilliant attorney, because I think she understands the law and I think she's very smart. But I agree with you. Her courtroom side of presentation is very, very much lacking as an orator and as that confident, owning the courtroom. Jackson, he prances around and, walks. And I mean, he's really a showman, as much as he is a lawyer. And that can be very good for whatever side you're presenting. I think Brennan has he has everything checkmarked, except for he's not going to do the, Tom Cruise strolling the courtroom.
Right.
He doesn't have
Saul Goodman.
Yeah. He doesn't have that. And for me personally, I don't like that. It just is slimy every time I see that. I think they're trying to get over on the jurors and on the evidence by being showy.
Yeah.
So I like Brennan. I find this interesting, this new addition. If they do not postpone the trial, how much time is he going to have to learn the trial, assuming he has a normal caseload, in New York? How much time is he going to have?
I mean, my guess is he's just being brought in for one specific thing, but, I don't really know. This must be something he has a little bit, to whether it's cross-examining a specific, like a medical witness or something like that, I don't know.
Yeah, you could be right. I was looking at his background and it's extremely technical and the energy side of things. I was having really a lot of trouble trying to figure out what nexus, what specialty he brings. Not that he's not, a great attorney, but how does he help this prosecution team? That I don't know.
So one of the things that we heard a lot about today from Brennan is how many times Karen has changed her story in all these media accounts. And that he also interestingly said that her story tends to evolve based on the latest revelation with discovery material. Really fascinating to hear him say that. I don't know if you caught that part. Just they want to expose all this by submitting those interviews, making that part of the evidence. Did you get to hear any of that?
I did, and I totally agree with his points. But I find it interesting because it's what we've been saying from the very beginning. Her story evolves. Her stories don't line up. They change all the time. Did he go in the house? Saw him at the threshold. He never left the back of the vehicle. I dropped him off. I went away. I left right away. I called him many times. I didn't call. I texted him. I didn't text him. Her stories, I really want to do a schematic on this, Kevin, to show the dates and times. Tuesday's probably already done it if I dig deep enough. The dates and times that she said what about what. In other words, It would be, that's what
That'd
the,
be great. Yeah.
if I were on that team, I would put that together and make that a huge trial exhibit.
And that's why they have to get this material, because if you're trying to get, you have to get the unedited footage. Otherwise, you can't just use what you found on TV. That's why we didn't see it last time. And they're running through this kind of ring system where even though some of this footage was from local affiliates, Channel 5 and Fox News, Channel 5 is an ABC affiliate, that material is still goes to corporate. So they have to, so now you're getting into a different state. And but my understanding from Kevin Mahoney was that it's normal to get that, and the state should have been able to get it in the first time, and there may have just been some, ineffectiveness in the way they filled out the process. Again, Lowy by himself or relatively by himself, but they won't fit, they should be able to get it this time.
They need to. It's
Yeah.
it's a must. And but I don't think she'll ever testify, so this can't be used as impeachment evidence.
Yeah.
But they still need it. They need this evidence.
Another interesting part was the reporter Gretchen Voss for Boston Magazine, who did an article in September of 2023 that is really still the best work anybody's done on this case. Really, really outstanding article where she not only extremely well written but so well researched, got on the ground and talked. She spent time with Turtle Boy. She spent time with Karen, got on the ground and met many of the early people that became early players in this. Last time they were able to get part of her recordings into discovery, but she was allowed to redact quite a bit of it. And so her attorney was here today. I think we all, not to be mean, but fell asleep during that part. So, so Brennan made clear that the redactions are important. They have reason to believe there might be redactions that could reflect her changing her story. And I knew Yannetti was in the room for those interviews, but apparently so was Little and Alan Jackson for those interviews. There was 3 series of interviews with Gretchen Voss, and also was a chance that Brennan used. So Voss's original arguments was that she was being terrorized by the mob and was trying to avoid having to testify and having to do certain things related to that. And Brennan used that to say, we sympathize, but this is important because we're entitled to that evidence. And it's not just you that's being terrorized by the mob, but it's every single witness in this case. And he managed to get that in there. I thought that was pretty good.
I thought it was really good. And his other point that he made that I thought was just excellent was about the fact that look at how this is distorting justice, which is the point we've always made is that you have to have witnesses that are able to testify without worrying about being harassed, about being bullied, tormented, tampered with. That's the crux of our legal system. And where you mostly have seen that is in cases involving the mafia, cases involving cartels, cases involving organized crime, drug and drug distribution rings. You don't think of it as being in this type of a case, and yet that's what we're seeing. And Gretchen Voss, for good reason, is very concerned because that's what they do. But he's right, within the 4 corners of the law, that has nothing to do with whether evidence should be submitted. You can't use a witness being terrorized as a reason not to call the witness or to produce that. You have to do other means, which he actually said that word. And that means she might need protection. She needs help in protecting herself from the mob.
That 4 corners of the law, I wonder if that's an expression that you feds used to use a lot, because Sean uses that a lot too. The 4 corners of the various this or that.
That's funny. Yeah, I think that's just a colloquialism that we use.
Okay.
Feds. Corners.
So I hit on this before you get on, but this is really important, and people had a lot of questions about this, and this came up at the end of this, and I have a little bit more on it from my notes. So the defense about a month ago filed a motion looking for DA Morrissey's communications, ex parte communications with the witnesses, and with lawyers and judges related to that. Now, we know that what had happened was the witnesses had come forward at that time complaining of severe witness intimidation and bullying. And so they had an emergency meeting. And so what the defense is saying here is that they know from at least some evidence that there were some communications by DA Morrissey over private phones or emails. And so we learned today that Brennan has been going through Morrissey's private emails and trying to comply with to satisfy the defense on any of this. But the defense went so far as to say we have reasons to not trust DA Morrissey. And so there's a protective order here that the prosecution just worked up and gave to the defense. Now, this is to make sure. So they also wanted the sidebars for some. They wanted a transcript of the sidebars during the trial for some reason, and related on this same issue. And so the prosecution wants to make sure none of this needs to get in the hands of Turtle Boy, so he can abuse it. So, they wanted to add this. So the defense wants to add these search terms: Reed. So for Karen Reed's last name, but under also apparently at one time Morrissey had misspelled it with 2 E's. He also wants them to search through DA Moore. So I think you know more about this than me, but when you're doing a search through somebody's private messages, you search through terms, right?
Sure.
And so he wants to. So Yannetti wants them to also search for the witnesses' names to see if there's any messages that involve that, the judges' names, any clerks or employees related to. So he thinks there's something shady here, but what you're going to find here is all they were trying to do was protect these witnesses from that information getting in the hands of the defense because they were going to leak that to their blogger.
Yeah, no, I agree. Look, what those witnesses have gone through, the McCabe's and the Alberts and this thing, their life is forever really ruined. I don't know how they could even live there anymore. I know that that's, where their families are and their friends, but I can't imagine going through what they've gone through. It's horrific, and everything they've suffered on social media. I think the only good thing about it is that, they're putting together suits and people will be charged. And they're when I say charged, not charged, they will be sued civilly for defamation. And they actually have the corresponding, horrible things that have happened to them, right? So that's the only thing that's going to save them. But that's why Morrissey came out and made that big statement. He said, listen, I've never had to do this before. But And the other thing was, and we saw this a little bit in the Idaho 4 case. I know you might not be familiar with it, but the 4 kids that were brutally murdered up in Idaho.
Yes, Moscow. Yep.
In that case, we saw the police come out weekly and say, listen, this person didn't do it. This person didn't do it. And give a list and say, we've cleared them essentially, right?
Right. Like her former boyfriend. Yeah, I remember that. Yeah.
Former boyfriend, the other boyfriend,
the food delivery guy. And I remember that.
Driver. Why? Because they were getting massacred on social media and they were being harassed. I mean, personally, just like what we're seeing in the O'Keefe case, except for what Morrissey did was he came out and, he made a great statement, I think, to say, listen, we don't have any evidence against any of these people. It's ridiculous. And so it's not unlike what was done in the Idaho case. What's different is how it was perceived. So instead of just saying, okay, we know these people are off the table, I wonder who did this. In this case, they said, all right, he's corrupt and we're going to go after these people harder. That's what ended up being the result of his communication.
Kyle has been trying to tell me to check out, and I have it up on the screen, but I don't know where to get them. So he's saying that Karen actually made statements to reporters this time outside the court. So if somebody knows where I can link that to, where I can find it, please let me know, and I will link to, I'll play it for us all. So it's hard for me to look while I'm live on the air. So if somebody knows where that is, I can put them up.
Oh, that'll be interesting to see. I mean, we've seen so many statements that I think were really telling. One was when Matt with Court TV said, well, you loved him, right, Karen? No, I didn't love him. We were in a short relationship. I mean,
Yeah, that was
that was that was big.
because it was such a change. Like she was always like, you know, when reporters would go to her house, she has a shrine that she puts up and reportedly takes down when, you know, but she puts it up for reporters, a shrine of John. And she's always tried, well, we were going to make our lives together. She had people going out. Yes, they were going to buy homes. But after that came out with Higgins and those texts, she kind of changed her tune. Well, we were just dating.
Yeah. And that's what she said, not a short relationship. Her exact words were, we were just dating. That, and, you know, referring, he was laying there like a buffalo on the lawn. I just think that anyone who has lost a loved one, which most of us have, right?
Yeah.
I mean, somebody in our life, certainly not tragically like this, but has lost a loved one. You just, the mention of them makes you sad and makes you, you know, not want to say anything derogatory. And it's the opposite effect we see from Karen. And recall, and I think this is important, not one tear toward that man.
I am told, and I should find this out, but there may be physical reasons related to her MS. I don't know that, that she can't physically cry. You know, again, I don't know that.
Oh, that's
So,
baloney. Let's wait and see if she's convicted if we see her cry. My money, if she's convicted, we will see tears.
in fact, I think she shed some tears in that interview she did, if not on Dateline, the other one, 2020, maybe it's 2020, when they interviewed her in the hotel, and there were two moments that she cried. One was talking about her mom and giving her advice about the dresses, and another one was about Patrick, something, the nephew. I think there might have been two moments where she did. I don't know if she physically cried, but she seemed to, and she got very emotional. So we're trying to be fair, right? So
I want to be fair, but by the same token, I just know of no MS. I'll look this up afterwards to make sure. I know of no symptom of MS that would lead a person not to be able to cry, but I'll look it up.
okay, I'm trying to see.
So I headed out, but I just thank your audience for tuning in. And Kevin, you know I love cutting up this case, and you're right. We have an obligation to be as neutral as possible. I'm just a fact finder. I go to where the facts go and then discuss those facts. So it is hard for me to overlook facts or away from facts. But yes, I agree. Both sides, very important to at least discuss both sides.
Thank you very much for being here. And everybody from our channel, I'm sure you already are subscribing to Jen's channel, Breaking the Case with Jen Coffindaffer. And so go check it out. She has excellent guests there in addition to doing her own great commentary herself. But thank you very much, Jen.
Thank you. Till next time.
Thanks. Till next time. I'm trying to find it, guys. I'm on YouTube. I've done a search. Nothing's up there yet. So if somebody else, I've been trying to watch chat too, or if somebody messages me, email me, text me, whatever. If somebody finds the link of Karen outside the courthouse, it doesn't seem to be posted yet anywhere that I know of. So okay. So Prissy, one of our regulars, says that she has MS too, and it's not the MS that makes you less likely to cry, it's the medicine. So it could be a factor here. It could be a factor. I mean, we're trying to be fair here. This one thing that we've learned, that I definitely have learned through just an incredible amount of close activity on this case, it's very difficult to break down human activity into a box. It's definitely not really usually possible. This person's bad, this person's good. Most people have both inside them. There's a little bit. So everything you see out there in somebody's conduct of this case, for most of those people, whatever they're doing, the ingredients for that soup are inside you too. They're inside you and me. And that doesn't mean we would do it. I'm just trying to say we're trying to understand how complex this is, because I do see people doing some things that are just reprehensible. And I'm not talking about people that believe just because they believe in one side or the other. I'm just some of the things that I've seen people do with making up material about other people, doxing them, or even grifting on this. Look at Julie Carpenter's ex. All right. So we might have a clue as to how to find this clip. Julie Carpenter is great. She's from Indiana, covering this case fearlessly and taking a lot of abuse. So now if I can find her on X. And I think I have got her. All right. Here is the lovely Julie Carpenter. Let's see if she has a link to this. She does. Okay. All right. So hold on one second. And let's bring in a clip from Julie Carpenter's Twitter. Make sure the volume's up. All right.
Jonathan.
Yes.
Isn't it amazing that ABC, NBC, Boston Magazine, and Fox all sat on alleged confessions and never publicized it? That's malfeasance on all your parts if that were actually true. That's a fishing expedition. They don't exist.
And are you
Jonathan.
Yeah.
All right. I don't know what you guys think about that, but that's ridiculous. What the prosecution is looking into are, and I do, yes, Brennan did at one point mention alleged confessions. It's, he's not saying that Karen went on ABC News and said, oh my God, yes, I did this. Wait, I changed my mind. Edit it out. No. But there are elements of her statements that I'm not saying that they amount to confessions, but they're entitled to make that case legally in order to go after these records. Some of Karen's words could be conceived of as confessionary, right? Certainly what she said at the crime scene, but also in the interviews when she says things like, could I have clipped him and stuff like that. Now, look, you guys know, or many of you here know my position on that. I do not believe that that she was meaning that she remembered clipping him. No. A lot of people disagree with that. Like I said, my job is to, if people aren't on both sides aren't frustrated me one time or another, then I'm not doing my job. I don't believe she's not stupid, and no one is that stupid enough to go on camera with a news company and say, well, I didn't think I hit him that hard at the crime scene or something like that. She's not that stupid. So if you're tending to think that that's what she was doing, you got to give it some serious rethink. It's taken out of context a little bit. And I believe that what she was saying was later on at the crime scene, when she says, I hit him, or something, or did I hit him, some version of that. I believe that what she's saying later on is that she's describing what's in her head when she was making those statements after John was found, which is very different from saying, I thought I clipped him or hit him at the time. She would not, even if she did clip him, even if she was aware of doing that, she is not going to be stupid enough to say that to a reporter. Now, a lot of people have talked about, we can pull this off. So we can go back to her discussions at the crime scene of I hit him. Now, some people, veteran law enforcement people, have said that this could represent spontaneous confessions, that people under stress will let slip out the truth. That's very possible. I don't dismiss that at all. I don't think it'll be decisive or convincing to a jury because they won't know. It's something that's open to interpretation. But I'm not at all dismissing the experience of those experts who think that that might have been what was going on there. All I'm saying is that we just don't know and maybe can't know what exactly she was saying and what was in her head. So were they spontaneous confessions? I mean, look, she was in a state of shock. You know, she looked at her hands inside when she sat down with Jen McCabe and Kerry Roberts in the police cruiser. She looked at her bloody hands and said, you know, oh my God, am I having my period? So her mind was fractured in that moment. You can take these off now. Her mind was fractured. She was in a state of shock or whatever. And so it's possible in that moment she could utter spontaneous confessions. It's just really difficult to know what she actually meant. But it's different when you're talking about the interviews because she's not under that same stress. So she's not going to stand before a reporter and say, I was wondering at the time as I backed up if I clipped him. No, it's not what she meant. So, but the prosecution is entitled to say, well, we don't know what she meant. It certainly sounds like a confession. So we need to see all of it to make sure. And that's what they're asking for because they sound like confessionary statements. You know, Karen's entitled to say what she wants to say. But the prosecution is not wrong. The judge understands what the prosecution is doing. The prosecution is not making an argument for the jury. She's making a legal argument for the judge that these words sound confessionary. So we need to get all the rest of it. And that's, I think that's going to win. So the prosecution is going to win this. They're going to win on that issue. And whether Karen understands that or not, or she's just putting something out for the media, I don't know. But that's what's going on there. We'll play it again. Let's play it again just to see if anybody has a different interpretation of what I just said.
Isn't it amazing that ABC, NBC, Boston Magazine, and Fox all sat on alleged confessions and never publicized it? That's malfeasance on all your parts if that were actually true. That's a fishing expedition. They don't exist.
And I all right. Well, you've heard my explanation of it, so you guys can let me know if you agree. Let me just glance through the notes and see if I didn't miss anything. And thank you very much, Jen, for being here. Jen's always been a great addition to the analysis. And we do a really good job when we have Kate, too. Kate, I'm not sure where Kate is. So Morrissey, they try to make it seem suspicious that Morrissey's texts are set to auto-delete after 30 days. I mean, on his personal phone, I would suggest that's just a way of keeping the memory on your phone clean. So on December 12th, we're going to have a Dauber hearing where they will question the qualifications or the arguments of the defense expert, Dr. Russell. So this could be potentially interesting because Dr. Russell already was brought in to do she was discovered or came forward on her own or whatever. There was mixed stuff on that in the middle of the trial. This was the woman who is a longtime retired ER doctor in Los Angeles, same place where Alan Jackson is from. And she does have a little bit of expertise on dog bites because she had done some peer-reviewed research on it. But I believe her research was about human bites. I'm not sure, but I'd have to see more on that. But she had some expertise on dog bites, and she was allowed to testify. The defense was allowed access to her, but now apparently the defense is going to challenge it again. Now I don't know. I'm not a lawyer, so are you allowed to bring in an expert? Is the prosecution allowed to bring in any kind of expert to challenge her? I don't think so, but maybe they are. That would be interesting. Is the prosecution allowed to submit new evidence? Were they able to get any kind of new evidence that would show that John was not attacked by a dog. Trying to think of what. They've already got the DNA testing of the clothing. You've already got the autopsy photos. I don't think you can bring in a new expert to argue with Dr. Russell, but you can, if there's new evidence, you can submit that. So I'm not sure what else there could be. So, for instance, I don't know if Chloe is still alive. Chloe's the German Shepherd. But let's say, hypothetically, if Chloe is still alive, then you could maybe get a casting of her teeth, of her, a dental casting, something like that. And maybe you could present that to Dr. Russell and say, can you see here that this wouldn't match? I'm I'm throwing stuff around, so I don't know if that's actually going to happen. There must be some reason, though, they're doing this Dauber hearing and they're going to challenge her. Heather Ann says Chloe is still alive. Good. I mean, I think the dog was 7 or 8 years old at the time, right? So I'm not sure. I don't remember from the trial. So, but dogs don't have very long lifespans, and it's an somewhat older dog. So, but I don't even know. Could you take a teeth imprint? Is that what it's called? There's a mouth imprint. I'm not sure what it's called. And if you presented that to Dr. Russell, would she be able to analyze that? Would that influence her argument? I don't know. So, but it does sound to me like if you're going to have this Dauber hearing, you would have to have something new that was not there in the original voir dire. Dental impressions. Thank you, Sky. Yes, that's the correct terminology. I have, I don't know. As I'm getting older, I have a slow head sometimes. I'm not able to find the words or the expressions that I need for something. I recognize them once somebody puts them up. I'm not smart enough to remember them. I'm smart enough to recognize them when somebody smarter puts them up. So thank you, Sky. Dental impressions. I believe that is the correct terminology for it. So if they had something like that, would they present it to Dr. Russell? Would she be able to analyze it? Because obviously you would be able to present it at trial with your own experts, but wouldn't it be better? It sounds like apparently the defense must have had a hard time finding an expert to come forward and say that the wounds on John were the result of a dog attack. They weren't able to find someone until the middle of the trial. So if they end up convincing Dr. Russell that it wasn't a dog attack, does that mean they won't have an expert? The defense won't have an expert that they can use for that. That would be very powerful. So they're leaving no stops. They're leaving no rock unturned. You can see here with the execution now, because much of the work was done before the first trial, and now they're filling in the gaps. This is Karen Reed trial part 2 in many ways. It's a different jury, so it's a whole new trial, so you will have to see all of that. So Maureen says that Chloe was 6 years old, so she'd be, what, 8 now? 8.5? So she'll be 2022, so she'll be 9 at the time of the trial, but Chloe is repped by Mark G. That's the comment of the day. That's the comment of the day. How come I'm not funny enough to think of stuff like that? Very, very good, Jane. I don't know who Mark G is, though, so I'm not trying to say anything about Mark G. I'm just saying that it's funny, the idea that Chloe is going to say. We've seen today Gretchen Voss's lawyer in there. We've seen lawyers from other witnesses and people involved in there. So does Chloe have a lawyer in there? Dr. Sheridan. Heather says Dr. Sheridan should also be excluded. She says she has notes in her testimony that are very problematic. Well, share those notes with us, Heather. You know how to get in touch with me. Dr. Sheridan was interesting character, Irish accent. He was a young doctor during the Civil War, and so he brings a lot of experience to the table. He predates anesthesia. No, I'm kidding. But I actually found Dr. Sheridan to be kind of interesting and charming to listen to. But in terms of his qualifications, I thought he did okay. I thought he did fine, but it does show you, defense teams do seek out and they can find experts that will kind of sell the story they want to be sold. But it's not always easy because that person has to put their reputation on the line too. So Christina's talking about Rita. So here's the question. Was Rita there today? Rita's been leading the charge on this with the stand-ins outside. She is a 4-star general in the Pink Army, but she was not invited to the fundraiser this past week, and she's understandably not happy about it. Joe says that Rita was not there. So, of course, it was a rainy day too. But Rita, so when I first went to I went to a hearing. I didn't go into the hearing, outside the hearing in April, pre-trial hearing, so right before the trial. And at that point, that was when the buffer zone was there. And I was walking towards the courthouse, and there was 8 or 9 people waiting at the buffer zone. And Rita was in that 8 or 9 people. So Tom CPU, and I don't know the names of the other people. I've recognized them so they've been at everything. And some of those people were also, when I went to Dedham to be on Court TV, they were there for that too. Rita was not there for that, for the Court TV thing. But, I met a lot of them and I got along with them. But yeah, it looks like none of those people were invited to that fundraiser. And so does that impact their willingness to support her outside? I bet it does. But it's hard for them because this has become their social life. And Rita ran for office based on this. So, Tom CPU said he got a +1 and brought Scott. I don't know. All right. I mean, but yeah, these people, I don't think it's, even if they're upset at Karen, I don't think it's going to be easy for them to just walk away from this, even if they're mad at her, because these are their friends now. This is their social life. These are their worlds. This is what, and some of them, it gives their life meaning. And that's a hard thing to give up. Getting sent another clip. So let me transfer it over and we'll see what we got. This might be just Karen again, but let me download this clip and see. What we got. So you guys getting ready for Thanksgiving? How you guys doing? Well, I get this clip ready. I'm hearing we might have a pretty significant storm, or significant enough to impact travel. And so for those of you that are going to be traveling on Thursday, all right, second. For those of you that are going to be traveling, I got to change the speaker 2 on this so it won't get feedback. That should not have come through that speaker. All right, I'm going to play this clip from the courthouse. I think it might just be the same one we saw, but maybe from a different angle. And but it might be a little bit different, so we'll see. And I will mute myself so we won't get any feedback. Hold on 1 second.
Isn't it amazing that ABC, NBC, Boston Magazine, and Fox all sat on alleged confessions and never publicized it? That's malfeasance on all your parts if that were actually true. That's a fishing expedition. They don't exist.
Yeah, are you consistent in your story?
Oh, Karen. You know, listen, if you're in a battle, whatever you think of her, she's in a battle for her life. One way to steel yourself up is to seize on anger inside you. And that's what she's doing here, right? So she's coming out, but she's very self-righteous, thinks she has all the answers. And that is not, like I said, that's not at all what the prosecution is saying. So maybe on the way home, the lawyers can explain it to you, Karen. But what they're saying is you made statements that are confessionary in nature because you talked about, could I have sideswiped him? Could I have incapacitated him in his drunkenness and those kind of statements? Those are arguably confessionary. Now, again, I don't believe they are confessions, but from a legal standpoint, you can make the case that they are, and therefore the prosecution has the right to get all of that unedited footage. So this is also a good time. So you guys are probably wondering where Tom is, and I'm not 100% sure, but his wife is flying back today from a long trip in she went to Rome. She is an arts professor, and so he may be in progress of picking her up at the airport, but I'm sure he's fine. But we have Joe here. I'm giving you guys my email because I haven't mentioned it yet. All right. So here's my email, leetskev. Oh, did it go through yet? It's still trying to go through. leetskev@gmail.com. And I welcome people that have ideas, suggestions, input. If it's civil, I don't care what side of the case you're from. I maintain civil discussion with people from the other side of the case. And or not I'm on not that we're on either side of the case, I should say. We'll stay on a little longer and then it's time for lunch. So I did. So somebody said, what was it, December 3rd? Let me just check this for a second. All right. So the message to me was that the chip off is December 2nd and 3rd in Texas. I'm not sure if that actually constitutes the chip off because my understanding of the process is you have to take the chips, send them to a lab in Texas, upgrade the software, solder them back onto the boards, but then take the boards back to Karen's SUV and put them on the SUV. I could be wrong, but that was my understanding of how it works. And because I believe things like, for instance, the GPS, I don't know what storage would still be on the SUV, but the GPS chip is on there and stuff like that. So I don't know when the chip off is in that process. I thought the chip off would be once they've restored it to the vehicle, but I really don't know for sure. It's a chip on. All right. So you guys can tell me if I've misdescribed that. So it sounds like the process begins on December 2nd. So next week, they go back to Texas. They come back from Texas with the chips and then put them back. It's not a chip off. All right. Well, in any case, if I'm not describing that perfectly accurately, I think I hopefully got the essence of it, that the chips and the boards will be updated and returned to the vehicle, presumably late next week or maybe the week after. And Karen's expert is allowed to be present and they will get that new data. Then the next step would be to analyze that data, which I believe in the last hearing, Brennan said would take about a week. So Matt's going to have a gin and tonic with cheers to me. And man, I wish I could have one with you, brother. I did get some stuff to drink for Thanksgiving. for other family that we have coming over, it's become kind of a tradition where I go to a package store that has beers from around the world, and we buy a bunch of different beers, and I kind of do, I eat, the beers are in they're little wrappers that come with a little brown bag, and it's like you pick one, and it's a grab bag kind of thing, so you don't know what you're getting. And so they might get one from Germany. Man, there was one that was from China. I'm like, I'm not touching that one. I don't trust the pollution in that water. But most of them are like from Germany. Oh, got some Belgic beer, which is, I think, if I remember right, is called a lambic beer, and it has some fruit in it. So hopefully maybe some of the women will get that at the party. But yeah, so we'll be doing some partying on that. And I also got my brother-in-law some Captain Morgan's because he likes Captain Morgan's and whatever other alcohol is around and people bring. So we'll do a little bit of partying on Thursday. Thank God the Patriots are not playing. That was embarrassing enough. Thank God. And I'm a sucker. All through the bad years, 70s, 80s, early 90s, I watched the bad teams for the Patriots. I've had Belgian wheat beer. Yep. A friend of mine, his wife was trying to order one of the blue shirts and reached out to Kate, and she hadn't got a response probably because Kate gets besieged. So if anybody has any ideas about what's the best way for them to order a blue shirt. I do agree, Mandy, on the no bottom teeth wounds. That's always been my position on it. But again, you really need an expert to talk about that. Her mother was bit by a dog, and when the dog clamps down, there are puncture-like wounds. Yeah, I would think that you might get some scraping on either the top or the bottom, but that you have so part of the jaw is used to lock on, and the other part is kind of like gnawing. So, but again, I this is why you need experts. I'm not an expert. So, Maui says Rita will be back. I think so too, because she's attached her political hopes to this, and this is her social life. So, when I was there, she had the bullhorn and was doing rants to the crowd and to the TV cameras, and she's invested very heavily in this, and she was shunned by Karen. So. I should mention too, so first of all, people were saying that I have signed or Matt Valentinas has signed me. No, I've never had any communications with Matt other than when he came on the show. That's it. So that's just a false rumor that they put out there. I have no communications at all. I do have his email now because he emailed me to get on the show that night. But other than that, I've had no exchanges of information with him. I messaged him after the show to say, if you would like me to delete that show, I will. And he didn't reply. So there's no communications there. I don't know if that's something that him and his partner Phelps or what a client discussed. At the time looked at it as though I'm reviewing an article. But in reality, given it second thought on my own, if somebody had sent me somebody else's private messages, I certainly wouldn't discuss them on the show. So the fact that Turtle Boy revealed these in an article, probably should not have done a show on him. So, or if I did a show, I probably should not have showed them on the screen. Let's put it that way. So, and once Phelps emailed me to say you don't have permission, I did take him off the screen and tried to discuss him without getting into specifics. I think that seemed fair, but obviously, as a general rule, it's best to probably just, I don't know. I thought they were fascinating and interesting, and from a making of the sausage kind of thing. But I definitely wanted to give Matt Valentinus all the opportunity to say what he wanted about that. And so I also tweeted something the next day about the podcast and put a link to the podcast in it. Or it was actually, I put a link to Matt. All I was able to find was Matt Valentinus, his post with the trailer to the podcast. So I linked to that. And that's why people think that I'm suddenly with Matt Valentinus, but no, I'm not. I put that in out of respect because I had gone over their emails. I mean, their private messages on the show, and maybe I shouldn't have. So I put that up, and I think it's got about 30,000 views. So hopefully that gave them a little bit of a jump. Kate Peter, is that the real Kate Peter? I've only seen her as Masshole. This could be someone trying to trick me. And next thing they're going to know, they're going to say something threatening about Turtle Boy. And it's because it's all a trick. But Kate, if it's really you, you can text me. Then I'll know it's you. If you don't text me, I'll probably boot you because I'm okay. Well, just because you're saying you're the real Kate Peter. Of course, a fake Kate Peter would say that too. So I did send you the link to the show. If you're welcome to come, I sent you the link last night, the stream link. Just wanted you to know. I emailed it to you. So I'll wait to see if I get a text from my friend Kate Peter. Oh, she's on. Oh, just so you guys know, you don't see it because she's on Facebook messaging me. She said it's her. Okay. Well, would you like to come on, Kate? But the link to the stream is in your email, but I can send it to you again if you want. I sent it to you last night. So if you check your inbox, you'll see it there. The crowd is cheering for you, Kate. Okay, well, come on now. We're here. We're here for you. Let me know if you need me to send it again. She's coming on. Be patient. Well, she's probably searching her email. There we go. Hi, Kate.
Hey.
Crowd is cheering.
Are they? No fake me's today, thank God. Yeah, that's exactly what would happen, though. It's like, a fake me pops up, and then all of a sudden is threatening Dick Nose, and then I'm, taken into court on another false complaint.
That's what I was worried about. Yeah, because I've never seen you in there as anything as other than Masshole. So I was like, Kate Peters in chat.
I happened to log into Facebook, which I don't do that often, and I saw that you were live on Facebook. So
I don't even think we're Facebook friends. I don't think we've ever communicated with Facebook. Oh no, we did a long time ago. That's
Facebook
right, we
friends,
did. Yeah, it's been a while. So yeah,
I don't really use Facebook. So
right, I think actually when you first reached out to me, probably like September of 2023, it was over Facebook.
Yeah, exactly.
Yeah, and it was great because I didn't have access to documents back then, and you were the first person. I'm a document reader. I want to go by the evidence. I don't want to, so that was great. That was how I used to get them.
That was the first red flag, I think, to a lot of people when I would reach out on, kind of across the aisles when I would go, well, have you read all the documents? And everybody would go, no, not for lack of wanting to, but because they were not provided. And, I think it's pretty clear now that they were, intentionally hidden from people so that they were only getting one side of the story.
Absolutely. All you would get was what Turtle Boy would put in an article a piece of it highlighted that he chose to put in there, or Karen chose for him, but so did you watch the hearing? Obviously, did you see the clip of Karen outside of court?
Yeah. I mean, that's just classic deflection too, right? Like, oh, well, if that's the case, then that's on the media. It's malfeasance on your part. And it's like, well, no, I mean, they have a different function than court. I think that, it's also kind of misdirection too, because that's not even what Hank Brennan was saying, nor what we know. What we know is that what has been put into public, are admissions and conflicting stories, right? So,
Right.
I mean, I think the Commonwealth is entirely justified in saying, well, let's see the rest of it. And the reason being is, in the form that it's in right now, I don't know that it would be admissible, right? Because it's not complete. So in order to be able to use that, it would be proper and appropriate to ask for the complete recording.
Exactly.
Or not just what was broadcast. And I think even what was broadcast, I mean, I've listened to 2 interviews that she's done where she's made statements where she's essentially agreeing with the Commonwealth theory on what happened, right? That's not good for your case.
Yeah, it's at least one interpretation of those statements. So the prosecution is entitled to say that and to get the rest of the unedited footage. Absolutely. Did you have any other thoughts on the hearing today? There was a lot gone over. Not exactly fireworks, but it was a very interesting hearing today. A lot of stuff.
I like Hank Brennan's style a lot. I do.
Mm-hmm.
I think that he's a good counterpart against the defense, the way that it's been going. I find that they're a little bit more subdued now, right? Their arguments just aren't as strong. And I think that he's probably going to get more that he's asking for than he's not.
Yeah. It was interesting too. Like before the trial, Hank and Yannetti had to interact, standing there for a moment to work with each other, and there was not that tension that developed over time between Lally and the defense team. So it was interesting. That may still develop once you give it time to grow into something more personal. Did you have it? So they went over at the end the protective order and the getting Matt Morrissey's private messages. Any thoughts on that?
I mean, I think that is. I mean, they're obviously accommodating it. I don't think there's anything there. I don't think that Michael Morrissey did anything inappropriate.
Yeah.
In the message that he sent, they keep saying extrajudicial, as if that was even a case that he was involved in. It was not. It was a civil harassment prevention order. It has absolutely nothing to do with the district attorney as far as the case stuff. Where it does kind of intersect with the DA's office, obviously, is that it has an impact on one of his witnesses. So I mean, I don't really. No baccarat player. I don't know about false complaints. I'm not much of a cop caller, and if I do, it's always real complaints. Yeah.
Mm-hmm. So I think it was a smaller turnout for both sides there. So we're talking about the possibility that Karen's side is thinned out because of that fundraiser where she didn't invite any of those people like Rita Lombardi.
Yeah, I'm going live tonight to kind of go over that and the reactions in more detail. But I mean, I don't have a lot of sympathy for the people that have been so zealously engaged in this bad behavior for so long. But I mean, objectively, that was a really dick move on Karen Reed's part. These are the people that have been out for her, rain or shine. I know that Rita Lombardi in particular was complaining about, people having lost family. I know for a fact that there are several members of her family that will no longer speak to her because of the antics. She's alienated herself in town. A lot of them have, going to these town meetings, picking fights, causing problems for themselves and the people around them. Really probably a thankless job, on top of the fact that these people are also opening their checkbooks and buying licensed merchandise and making donations, and the thanks that they get for that is to be snubbed. And I know that they tried to play it off like, oh, it was mostly Karen's personal friends and family. That is a lie. I have I have been getting smashed with people that were there at the party. they're now
And they put out the video, so we can see who was there.
Right, they're not. One woman, her name is Jen Murphy, and she's really riding hard for Karen Reed. She met Karen Reed for the first time at that party. So I think what happened was they excluded the lower donors, and they only invited YouTube creators and the higher donors as some sort of appreciation and reinvigoration, right?
Yeah.
But I mean, it's easy enough to sit at home and send a PayPal or cut a check, right? Like these people, there would be no media coverage without all these people that went on the street and made a spectacle. That's what brought the news cameras. That's what elevated this, really, and those people were completely left out, and I understand why they're upset. You shouldn't be doing that shit anyway, but you surely shouldn't be doing that shit for somebody who doesn't even appreciate it, and Karen Reed does not appreciate it, clearly.
So the way it went out is people that were invited could bring a guest. And so some of the people that were in there might have been like this woman there who wasn't even necessarily a content creator or active in the Karen Reed movement, but was somebody's guest. In theory, someone could have invited you or me, Kate.
I would have declined. I would have declined.
I would have gone just because I love a spectacle like that. I love to be a troll.
Right, and I think Comfort and Joy in your chat brings up a good point too, is that they kept it a secret, and it wasn't a very good secret. Like we all kind of knew that something was coming because they kept referring to it. I didn't know the venue or time or anything like that, nor would I care, but like it was apparent that something was going on. And I could, and I will tonight pull up on my Discord messages where we called it early on in the Discord group when, they're going, oh, something's coming. I'm like, yeah, it's dinner with Karen Reed, right? There you go. Like, it wasn't hard, but it wasn't us that they were keeping secrets from, because how many events have they had, right? And nobody ever interferes. They've had numerous fundraisers. They have their little standouts. Karen Reed shows up to the standouts. Nobody on the, O'Keefe family side here has ever interfered with those events or made it uncomfortable or disrupted or anything at all. We leave it alone. So it's not us that they were keeping the event a secret from. It was Karen's own followers that they were keeping the event a secret from. And I understand that one of the excuses that they've given is the limited, seating, the capacity of the venue. But I mean, they're always going to VFWs and Moose Lodges and stuff like that, where there's not necessarily a high capacity, and they sell tickets and there's never a problem with anyone being left out. But Karen Reed is not present at those. Karen Reed doesn't want anyone there who is too poor or too embarrassing. And I think Rita Lombardi is the latter. Right. And a lot of the other people that stand out, for her are probably the former, unfortunately. She doesn't have time for that. She does not. I have it on good authority at this point, with all the free Karen Reed people, some that are still actively in there, some that have, kind of turned away or been chased away. Karen Reed regularly shit talks her followers. She has nothing but contempt for them. So she doesn't want to be around them. That's abundantly clear. And I think her way of vetting that out is these private, invite only events where there's a high price tag, because that kind of keeps the riffraff, as she would define it, out. And that's pretty shitty.
The one time I went on Turtle Boy's show, he said something amazing. I was criticizing some of the stuff that gets said, but it was not by him. He wanted to make clear, well, that's not me. That's the Turtle Riders. And he goes, much as I love them for all they do, don't confuse me. I'm not them. I was wow, you just shat on your own audience right there. Like,
there's nobody more vile than him. I would argue. And they all follow what he does. And I think Matt Valentinas kind of hit the nail on the head when he was on your show the other day. And he said they'll do what he tells them to do, and that's true. And there's no better evidence of that than the treatment of the O'Keefe family. That nobody has any real motivation, personally, I would assume, to go after the O'Keefe family. But Karen Reed gave the order to Aidan Carney, and Aidan Carney put it out to the audience. These are bad people. We don't like them. Go after them, and everybody did.
Mm-hmm. Absolutely. Sorry, just got a message. I always check. You do this too. We always check these messages during the show, because every once in a while it's something that the audience would be interested in.
Yeah, I just got a message too. So.
Okay. Okay. Anything else going on? I think I already hit my points before you guys came on. Before you came on, I did. So we talked about. So somebody that we know down at the scene sent me a video that I played on that showed Turtle Boy going into the handful of people there from the blue side, and he was trying to kind of taunt her by saying, how come there's so few of you? And she's like, people got to work. And he's like, what? You don't think, where's your job? And she obviously wasn't going to tell that. And she's trying to suggest that people on the other side maybe aren't working. But I think the other issue is that the people on the other side have turned this into their social life. This is what they are for. But the people that are showing up for the blue side are there because they've seen so many videos of the family and the witnesses walking in and being brutally harassed by that other side. So they're really just there to be protective of the family. I think that's the only main motive for them being there. Would you agree with that?
Yeah, I mean, it's harder as the weather gets colder. I think we're really trying to conserve energy for the actual trial as part of it. People do have to work. The threat of harassment is obviously very real. If you're out there, there's, I hate to say it because I don't want to discourage people, but there is a very real chance that you will be doxxed online later. And obviously he wants to know things like, where do you work? Who's your family? For nefarious purposes. I understand. I got a lot of feedback that when he started, hitting me with the lawfare, that people were afraid of that happening to them. I would reiterate again that I don't envision that happening to a lot of other people. I am very outspoken and I tend to get the brunt of it because of that I'm not everybody, but there is, some legitimate fear in there. And I think that that's why he's not taunting, he's gloating. He's going, I shut this down. And what a horrible person you have to be to actively try to shut down support for the family of a murder victim and then gloat about it. But that's who he is as a person. He's a terrible, terrible, reprehensible human being, subhuman. And I am feeling really, vindicated, I guess, that other people are now seeing that as well, because he got in bed with two consummate professionals who certainly don't have the personal history or, entanglement that I had with Aiden Carney when I left his blog. And they are seeing the exact same thing that I have been yelling for years, which is this is a man who is quite possibly a sociopath, definitely a narcissist, and is absolutely impossible to work with. There's absolutely no good faith effort going on there. And that extends to every single part of this trial that he tries to touch. It's just poison.
Mm-hmm. Well, I mean, I'm kind of getting ready to go for lunch, but I just want to add one thing on that, so they're kind of at war on Twitter now, and Matt Valentinus is kind of regularly saying you're a pervert, you got 18 counts of witness intimidation, and he's talking about the Lindsay stuff. But in fairness, it has to be pointed out, you knew that when you signed him. You knew that when you signed him. You were following him since 2020. You were following him through this case. You certainly knew that he was indicted. You certainly knew all that stuff that was going on. And you formed a kind of partnership with him where you promised him 40% of the download material, which means Matt Phelps is doing, probably assumingly getting his only 40% too. So he's getting the same as Turtle Boy, but having to do all of the work, or 95% of the work. Kate, it's a lot of work to edit videos, to go over all that trial testimony and then find the clips you want to use and then put them in and edit. Matt Phelps had to do a tremendous amount of work on every single one of those episodes. That's something that's...
the research, the scripting, the post-production,
the writing,
right? And I'm sure that Matt Phelps has probably fallen into this, as I have, as you have too. You research this, you build connections with people, you become another sounding board, you become another avenue of support. I don't believe that Matt Phelps is the kind of person to turn people away, particularly with how victim-centered he is. So it just becomes a tremendous amount of work. Yeah. And I think, to a certain extent, it sounds like them requesting these things of Aiden was tactical, and kind of part of the story to say, okay, we know what we know. How much is he going to let us know? And they found out very quickly that he'll lie, right? I was fascinated and very excited to hear the rest of the series. I'm not that I wasn't already, but when Matt Valentinus gets up here and says, we caught him in lies, in his own words on tape.
Yeah, I mean, I do think that they just from a production level, that help is appreciated. So Matt had reached out to me for certain things too. I'm sure maybe you too. And was happy. I got him, for instance, the Scanlon interviews and things like that. Not the audio, but when the troopers interviewed him. It's an enormous effort. And if you don't have a team of people doing this stuff, you do appreciate anybody, whether it's people you're working with. In this case, they kind of have a partnership with Turtle Boy, making that a little easier to get you some of that material. And I think it was just a part of that. I don't think that they had formed necessarily. Well, I mean, if you take those messages at face value, and I kind of do, that as late as the midsummer, they believed in the conspiracy, um, but they did the right thing and trying to get opinion from both sides, and then looking at the evidence yourself. So Matt would having had to go through all of that trial testimony. Now you're really getting into the nuts and bolts of it, and while you're doing that, you've got in mind what you were told by people from both sides, Turtle Boy and whoever, and me and whoever he talked to on this side, and then you're making up your own mind. And I think that's at the end what they did.
Right. And I think a lot of this is really muddy. And I mean, Aiden does a really effective job at creating an echo chamber and demonizing anyone who is going to pose any sort of threat to his narrative. Right. And I respect and understand that for an objective, neutral party coming into this, it might be hard to parse through at first, but at the end of the day, you're still working with Aiden. Right. And at some point it becomes self-apparent what kind of person he is, which is a huge red flag in the wider scope of the Karen Reed case for people, right? Because then you're like, well, why is Karen teamed up with this guy? Why are they working so intimately when he's just so awful? And he's doing these things that are not just morally reprehensible, they're illegal, right? And he gets arrested and then later indicted. And why is Karen Reed still hanging around? I don't know about you, but I found it to be almost comically blunderous move that she sat in a room with all these people who have either been charged with or named in connection with the witness intimidation. And not only is she sitting with them for hours, she's fraternizing, she's taking pictures, she's taking videos, she's connecting herself even deeper to this, knowing damn well, and obviously being worried about the potential for another grand jury.
Her lawyers are strangely allowing all of this, just like her lawyers. We learned today, we knew that David Yannetti was with Karen for the Gretchen Voss interviews, but it sounds like so was Little and so was Alan Jackson. So their lawyers are on board with this, everything that she's doing in this media campaign. And it's just another strange aspect of this case. You don't usually see lawyers allowing because look at and Brennan pointed out today how she's changed her version of the story in these media accounts and how it's evolved. Her story evolves based on the latest discovery material that gets entered in. So if nothing else, she has changed where she saw John walk to, what door he used, things like that. And we may get more if they get that unedited footage. So that was a motive. That was an argument for getting that evidence. So it is kind of an amazing case that her lawyers are allowed this to go on.
I think it's ill-advised, but I think at the end of the day, they work for her, and she's clearly a very type A personality. I don't think that Karen is used to not getting what she wants, and I mean, they're being paid enough that great, you got to kind of listen to her. It's my understanding that at some points they have tried to caution her, particularly against her involvement with Turtle Boy. But and that's out of David Yannetti's own mouth, right? In an article that was done, so I think it was an alum article from his alma mater. I'd have to go back and look, but he says, I was familiar with Turtle Boy. He completely decimated one of my clients. I warned her against this, but she won out in that one. Did she really win? Probably not. I would be keeping an eye on the next couple of weeks and what is coming for Karen Reed, honestly.
And it's interesting, just from a strategy standpoint, we can't say that it failed either, because we know for a fact there was a level of jury contamination where the alternate juror showed up the next day wearing pink. So that suggests she shouldn't have been on that jury. And then we know the dismissed jury, that whole story is just really, really bad. So we don't know if any of the other jurors, now the jurors that Turtle Boy interviewed didn't seem to have been impacted that, but who knows? But all it takes is one to get on there, and you're looking at a mistrial. So maybe that seems to have been the goal from the beginning, is a mistrial here. Otherwise, why have this extensive stirring up this mob and this media campaign and stuff like that? Because that media campaign is not going to convince 12 jurors, but it might convince one or two, and that can be a difference on a jury that needs to be unanimous.
Yeah, but then, the prolonged attacks on every witness and prosecutor and investigator sort of ensures that they'll probably try it as many times as they have to. So, I mean,
Yeah.
I guess what she won was, the mistrial, which then gives the prosecution the benefit of tightening up their case, which clearly they are doing. I mean,
Oh, yeah.
the facts and the evidence aren't going to change no matter how many times she plays this game. And then,
Right.
at some point, people are going to pay more attention. And we're seeing that happen, with the Phelps podcast and with other projects that are coming in the future. There is a shift occurring here. I don't know that this was in Karen's best interest at all, unless she wants to spend $10 million and end up in prison. That's, I guess, if that's your intention, then you're really doing a good job of heading there.
Is it a slam dunk that if there's another mistrial, that the state will just keep redoing this again and again?
I would assume so, based on everything I know. Yeah, I don't think that they're going to, because you really, she's put them in a position where they can't let it go.
Mm-hmm. Okay. All right. So I'm ready to have lunch unless you have anything else you want to add.
Nope. Thanks for chatting with me.
Thanks for being here, Kate. Look forward to talking to you again soon.
We'll be on tonight at 8.
Okay. I will be there for a bit. Thank you.
All right. Bye.
Okay, guys. So we're just going to wrap it up here. I have to go have lunch and I am tired. But again, thank you all for being here so much. At some point this week, me and Karen McCormick will be going on to discuss Tuesday Gazette's excellent article. She always has an excellent article out. And, as Brennan is far superior to Lally, I just want to pay respect for the work that Lally has done so far. And nobody has maybe publicly been more frustrated with Lally than me. But I also want to say that he's also done a lot of good work too. And he's a person of integrity. And most important thing is to get justice here. But I would have loved to seen him get the win. I am glad they brought in Brennan. But I feel a little bad for him, and I do wish that he would have got the win. But hopefully, if they do get a win, he did his part. And hopefully he feels, as he rightfully should, that he shared in that win. Because I think he did a great job at debunking the conspiracy theory. And now we're going to see, hopefully, Brennan take the ball and run the rest of the way and prove the state's case. So that's very important. Thank you guys for being here. Hopefully Tom will be back soon. I think he's on his way to an airport.